Good morning. I'm Ward 1 Councilmember Brianne Nadeau, the Chair of the Committee on Public Works and Operations. Today is Wednesday, February 18th, 2026, and I'm calling to order this meeting of the committee in room 123 of the John A. Wilson Building, as well as over the Zoom platform. The time is 10:55 a.m. Today's performance oversight hearing is for the Office of Human Rights and the Office of Contracting and Procurement. The first agency on today's agenda is the Commission on Human Rights, followed by the Office of Human Rights, both integral entities in upholding civil liberties and rights in the district. The Office of Human Rights is an important agency, and its primary function is to enforce the D.C. Human Rights Act and other local and federal civil rights laws. The Human Rights Act serves as a cornerstone of our legal framework, rendering the discrimination unlawful across 23 protected traits for residents, visitors, and workers in the District of Columbia, encompassing employment, housing, public accommodations, and educational settings. However, acknowledging the imperfections in its implementation, we anticipate valuable insights from public witnesses today on refining both its protective measures and the agency's adjudication process. OHR is charged with providing a legal process to those who believe they've been discriminated against. It offers a right to sue in the D.C. Superior Court and/or an opportunity to seek administrative remedies before the Commission. Upon filing a complaint, the agency conducts an intake interview, attempts mediation, and proceeds with an investigative phase to ascertain facts. Subsequently, the agency's attorneys present their findings to the director, who determines whether probable cause exists for discrimination violation, potentially leading to formal charges. Following this initial phase, the Commission on Human Rights assumes jurisdiction. An administrative law judge presides over evidentiary hearings, formulating recommended rulings and associated penalties. Ultimately, a panel of commissioners provides an impartial perspective, culminating in a final decision. Despite this seemingly linear process, the complexities inherent in discrimination complaints often prolong litigation, particularly for litigants who represent themselves. Today's hearing aims to delve into the Commission's staffing shortage and other pertinent challenges. On matters of the Commission, we will be hearing specifically from the Director of the Office of Human Rights, Kenneth Saunders. Nope. Yep. Elizabeth Fox Solomon. We're all human. That's our oops for today. And Chair of the Human Rights Commission, Motoko Aizawa. The second agency on today's agenda is the Office of Contracting and Procurement. The mission of OCP is to obtain quality goods and services through a streamlined procurement process that is transparent and responsive to the needs of government, agencies, and the public. OCP bears an enormous task. It provides contracting and procurement services to 79 district agencies. It's also tasked with ensuring that all purchases are conducted fairly and impartially. Today, we will hear from Director Nancy Hateman, we got that one right, about the work of OCP over the last year. During this hearing, I want to address concerns raised by the community, including issues with the solicitation process, programmatic outcomes, and the Act for findings presented last week. I also want to explore potential changes to contracting and procurement practices to ensure they're meeting contractor and agency needs, and receive updates on the past modernization project and related technological modernizations. I look forward to hearing from our public and community and government witnesses today. We value your input, and we're grateful for all you do for district residents. Okay, so we have a number of public witnesses today, both in the Zoom and in person. When I call your name, if you are in the Zoom, you will receive an invitation to be promoted to the panel, which you must accept in order to have access to your camera and microphone so we can hear you testify. If you are in the room when I call your name, please seat yourself at the table. And in the Zoom, for any technical difficulties, send a message to our host labeled as the Committee on Public Works and Operations, or anyone labeled as committee staff. But you can also email us at publicworks@dccouncil.gov, and we can assist you. All right. If you are repping an organization, you'll have 5 minutes to provide testimony, and all other witnesses will have 3 minutes. We are going to begin with our first panel regarding the Office of Human Rights. That includes Maggie Snow, Anti-Hunger Program Associate, or SNAP, at DC Hunger Solutions; Katie McConville, Policy Counsel at the Council for Court Excellence; Zachary Ragon, Policy Director at the National Reentry Network for Returning Citizens; Elizabeth Butterworth, Legal Counsel for the Elderly, who I believe is virtual; and Adam Marshall, Neighborhood Legal Services Program. Don't know if, what's that? Might be virtual too. Let's see how this goes. Don't see Adam in the Zoom either. Okay, we do have one more seat. So let's just see. Just checking. Okay, so this portion is OHR. If there is anybody else in person who wants to testify for Office of Human Rights or Commission on Human Rights, please come sit. Okay. Otherwise, we will move forward with this panel, with our one virtual witness on this panel, and then our next panel will be fully virtual. Okay, 1, 2, 3, 5. That works. All right. Snow, you may begin when you're ready.
Good morning, Chairperson Nadeau and committee members. Thank you for convening this hearing and for giving us the opportunity to share testimony. My name is Maggie Snow. I'm the Anti-Hunger Program Associate overseeing our SNAP work at DC Hunger Solutions. I'm also a Ward 3 resident and member of the DC Language Access Coalition. In my role, I provide direct support to residents experiencing hunger and use their feedback to inform my advocacy efforts. In FY25, our organization pre-screened over 1,300 residents and helped over 700 apply for SNAP. Most of the clients I assist speak Spanish and require translation services to access SNAP and other public benefits. We're grateful that DC has such strong language access protections in place, but there must be a stronger enforcement mechanism to ensure that agencies actually improve their services after a violation. We recently learned that the Department of Healthcare Finance, or DHCF, is one of the lowest scoring agencies in terms of language access, based on an annual study conducted by the Equal Rights Center. This is a major concern, especially right now as clients are receiving notices about changes to SNAP work requirements and alliance coverage. Without proper translation, clients cannot access these notices and respond appropriately. We work closely with DHCF and the Department of Human Services on SNAP cases. I regularly see cases where clients receive notices that are partially translated or poorly formatted after automated translation. Clients are greeted in English on calls to the ESA call center and abruptly put on hold while waiting for an interpreter, even after they've pre-selected their preferred call language on their keypad. Clients experience long hold times, often upwards of an hour, and dropped calls while waiting for interpreters on calls to the ESA call center. And also have difficulty communicating through the language line interpreters provided by the ESA call center. In one particularly challenging call, I had to interject when I realized a language line interpreter translated something incorrectly. We know that these experiences are not unique to our clients, and while the Language Access Act of 2004 establishes clear regulations for language access, it does not lay out clear consequences for agencies that violate the act. We believe that an explicit fine structure will affect real change at agencies, specifically those that have many violations. Improved language access benefits everyone. Clients are better able to respond to agency requests, and agencies are better able to respond to client concerns. Thank you again for the opportunity to offer testimony on the performance of the Office of Human Rights.
Thank you very much for your testimony. Ms. McConville?
Thank you, Chairperson Nadeau, for the opportunity to testify today at the Performance Oversight hearing for the Office of Human Rights. My name is Katie McConville, and I'm providing my testimony in my capacity as the Policy Counsel at the Council for Court Excellence. CCE is a nonpartisan, nonprofit organization with a mission to bring people together to conduct research, educate, and advocate to make DC's unique legal systems more just, equitable, and accountable to the community. For over 40 years, CCE has worked to improve the administration of justice in the courts and related agencies in DC through research and policy analysis, convening diverse stakeholders, and creating educational resources for the public. My testimony addresses OHR's role in two areas: implementation of the Second Chance Amendment Act of 2022, the SCAA, and resolution of employment-related complaints arising from the DC Department of Corrections, DOC. First, the Second Chance Amendment Act. The SCAA allows individuals with certain misdemeanor convictions to petition for record sealing 5 years after completing their sentence, with automatic sealing after 10 years for eligible low-level offenses. Individuals with felony convictions may petition to have records sealed 8 years after sentence completion. The law also mandates automatic expungement for certain records tied to decriminalized, legalized, or unconstitutional offenses, and for individuals found innocent or otherwise cleared. Importantly, the Act prohibits criminal history providers from reporting records that have been sealed, expunged, or set aside. Under the Act, DC courts must automatically seal and expunge all eligible records by October 1st, 2027, and OHR has the exclusive authority to adjudicate complaints and impose penalties for violations. That enforcement role is central to the law's effectiveness. Criminal records, including those for offenses later legalized or deemed unconstitutional, continue to create often insurmountable barriers to employment when relief is delayed or denied. Although the SCAA took full effect this past March, there is limited public information on how many records have been sealed or expunged, how many complaints have been filed, or how they have been resolved. With about 2.5 years remaining before the deadline to complete automatic record sealing and expungement, transparency and accountability are critical. We urge Council to require OHR to publicly report on the number and nature of SCAA complaints, including whether probable cause was found, whether violations were first or repeat offenses, and whether penalties were imposed. This would allow policymakers and the public to assess implementation and address challenges before the deadline. To the same end, we also encourage OHR to report on allegations under the Fair Criminal Record Screening Act, including prohibited inquiries on employment applications or into an applicant's criminal history. Lastly, we urge Council to ensure OHR is adequately funded. Although OHR's FY 2026 approved budget included $296,000 enhancement for 2 full-time equivalents to support SCAA implementation, this is well below the 2022 FIS estimate of $553,000 for FY 2026. That FIS also did not include additional funding for FY 2027, which OHR will need to assess complaints under the Act. We urge Council to provide OHR with the necessary funding to support positions and resources necessary to address complaints arising under the Second Chance Amendment Act in FY 2027. Turning to DOC, in 2024, an audit of DC jail facilities reported that staff filed 15 Equal Employment Opportunity Commission complaints alleging discrimination or retaliation. Staff also described persistent harassment and disrespect affecting resident morale and well-being. Public reporting on OHR complaints is not broken down by agency, making it difficult to track trends at the Department of Corrections. At its February 6th oversight hearing, DOC reported a 15% vacancy rate. That's 105 unfilled positions, requiring costly reliance on overtime, with $30.5 million spent in FY 2025 alone. While recruitment is often cited as the main challenge, retention is closely tied to workplace culture. Environments that tolerate discrimination and harassment contribute to attrition, fueling vacancies, overtime, and unsafe conditions. We urge OHR to publish quarterly agency-specific data on the number, type, and status of complaints filed by DOC employees. Regular public reporting will strengthen oversight, promote accountability, and allow Council to address systemic issues before they deepen. Thank you.
Thank you. Go ahead.
Good morning, Chairperson Nadeau. My name is Zachary Rigoni, and I serve as the Policy Director for the National Reentry Network for Returning Citizens. We work directly with returning citizens navigating reentry in the district, not in theory, but in practice. We see where policy works, where it falters, and where well-intended protections fail to translate into measurable outcomes. The district has taken meaningful steps through the Fair Chance employment and housing legislation. These laws recognize a basic truth. Employment and housing stability are foundational to successful reentry and long-term public safety. Today's testimony is not about the intent of these laws. It is about whether the current enforcement structures ensures those protections function in practice. Recently, one of our clients applied for a position with a national retailer operating here in the district. He never received a conditional offer of employment. Instead, following a successful interview with the local office, he was contacted by a corporate representative and asked detailed questions about the nature of his offense, including specifics about the circumstances and the victim. After a lengthy and uncomfortable conversation, he ended the call himself. Days later, he was informed he was not selected. He was generally aware of Ban the Box, but believed it simply meant criminal history could not appear on the application. He did not understand the timing requirements under district law. By the time he learned more about his rights, weeks had passed. He had no documentation of the conversation, no written confirmations of the background checks he was told occurred, and no realistic expectation that filing a complaint would restore the opportunity. He was navigating the time demands of supervision requirements, employment instability, and housing concerns. He ultimately chose not to pursue action. This case illustrates a pattern we see repeatedly. Whether the specific situation constitutes a legal violation is not the central point. The point is that enforcement of fair chance protections depends heavily on an individual's awareness, documentation, and capacity to pursue recourse, often while navigating the instability of reentry. The individual's experience reflects a broader data reality. Returning citizens are not disengaged from the labor market. Among formerly incarcerated individuals aged 25 to 44, labor force participation rates exceed those of similarly aged peers in the general population. They are actively seeking work. Yet research consistently shows that applicants with criminal records are over 50% less likely to receive a callback than identical applicants without records. The presence of a record cuts job offer likelihood roughly in half. Against this backdrop, OHR's FY24 report reflects 8 employment complaints under FCRSA and 2 housing complaints under FCRSHA. 8 and 2. That is not evidence of compliance or success. That's evidence of structural barriers to enforcement. The district's fair chance laws primarily regulate timing. They prohibit criminal history inquiries before a conditional offer and require certain procedural safeguards afterwards. Criminal history or returning citizen status, however, is not currently a protected characteristic under the District of Columbia's Human Rights Act. As a result, the framework regulates when criminal history may be considered, but not the breadth of exclusion once consideration is permitted. More importantly, enforcement is almost entirely complaint-driven. Several structural barriers limit the practical impact. First, awareness gaps persist on both sides. Many employers may not fully understand the district's specific requirements. At the same time, many returning citizens have only a vague understanding of ban the box. Second, transparency and documentation are limited. If an applicant does not receive a callback or is informally rejected prior to conditional offer, there's no documentation indicating whether criminal history was considered prematurely. And third, the incentive structure discourages enforcement. The current framework expects individuals navigating supervision, housing instability, and employment searches to pursue an intensive complaint process. If a civil rights structure only works for people who can navigate it perfectly under ideal considerations, it isn't meaningful protection. It's a procedural gesture. The district has an opportunity to decide whether fair chance policy should now prioritize strengthening transparency, accountability, and proportionality. It may want to consider ways to strengthen its fair chance legislation through measures such as establishing a right for applicants to request written affirmation that no criminal history inquiry occurred, providing proactive compliance review authority to OHR with respect to large employers and property managers, and expanding proactive outreach to major employers and property management entities in the district. Beyond strengthening the existing laws, the district should seriously consider whether returning citizens warrant broader protection under the DCHRA. Under the DCHRA, it would shift the legal analysis from whether procedure was followed to whether exclusion itself is justified. Employment and housing access are not abstract policy goals. They're central determinants of recidivism, public health outcomes, and long-term public safety. Oversight provides an opportunity to ensure that the commitment translates into measurable impact. We look forward to working with the council and OHR, and we thank you for the opportunity to testify today.
Thank you. We'll now hear from Ms. Butterworth in the Zoom.
Thank you for the opportunity to testify today. I'm not sure what's happening with my camera. Let me try this. There we go. Thank you for the opportunity to testify. My name is Elizabeth Butterworth. I'm a staff attorney at Legal Counsel for the Elderly. LCE defends, protects, and empowers DC residents ages 60 and over. LCE's tenant advocacy and support practice prevents the eviction of the district's lower income seniors and secures affordable, habitable, and accessible rental opportunities. Many of the tenants my colleagues and I represent face discriminatory barriers to securing housing and aging in place. LCE shares the Office of Human Rights goal of eradicating discrimination and protecting human rights of district residents. Our work offers daily reminders that strong civil rights protections are only meaningful when they are enforced, and we are grateful for the vital role OHR plays in offering an accessible venue for victims of discrimination to bring complaints and enforcing federal and local law. We currently represent 4 tenants in the investigation stage of the OHR process. All 4 have had a similar experience in OHR. Long delays at each stage of the complaint process result in extended harm and delayed relief. The first delay occurs between intake and mediation. Between filing the intake form and mediation, one of our clients waited 7 months, one waited 8 months, and 2 more waited 11 months. During mediation, further delay arises from basic scheduling and communication failures. For example, in one case, respondents' counsel requested a brief continuance of mediation to review our written settlement proposal with their client. We consented to ensure a productive mediation, despite both parties promptly sharing overlapping availability, and despite us following up with the mediation unit 3 times, the mediation was not scheduled for another 4 months. If mediation is unsuccessful, complaints languish in the investigation stage of the OHR process. Of the 3 complaints we filed in 2024, the first meaningful communication we received from an investigator happened 8 months, 9 months, and 1 year following mediation. In other words, these cases have now been ongoing for nearly 2 years with no indication of when the investigation may conclude. The delays at each stage of the OHR complaint process compound and cause serious harm. While tenants wait for their cases to move through OHR, they face ongoing discrimination. For our clients, facing discrimination in their home causes trauma and daily stress. Most started experiencing the discrimination long before they filed a complaint. Taking legal action brought not only hope for relief, but also additional stress and fear of retaliation. And then waiting almost a year between initiating a complaint and the first stage of mediation can be both emotionally unbearable and physically dangerous. For example, our client, Mr. M, is an 81-year-old tenant who experiences severe pain when climbing stairs. He lives in the basement of a building without elevators. For years, his landlord denied his reasonable accommodation request to transfer to an apartment on the first floor. He filed a pro se complaint with OHR in January 2025. We represented him at a mediation in September. The mediation was unsuccessful, and we're still waiting to hear from an investigator. In the meantime, he's had to delay necessary surgery because while recovering, he wouldn't be able to use stairs at all. And the ongoing discrimination has escalated and resulted into a health and safety emergency with OHR as his only hope of relief. OHR serves a vital function in the district, but currently is not operating effectively to deter discrimination and provide justice to DC residents who are victims of discrimination. We recognize that delayed timelines our clients experience are partially the result of funding and staffing limitations beyond the control of OHR leadership. And we appreciate OHR's openness to feedback. OHR recently met with advocates to discuss our concerns about delays in the mediation process, and we look forward to ongoing collaboration and are hopeful that it will yield positive change. At the same time, we want to emphasize that while cases spend years in the OHR complaint process, tenants across the district are denied equal opportunities and face the daily indignities due to their landlord's refusal to comply with the law. We urge OHR to take immediate steps to streamline internal processes, implement consistent staff training, and make every effort to reduce the delays experienced by complainants. And we also urge the council to both exercise its oversight authority and prioritize ensuring that the budget allows OHR to timely meet the needs of district residents facing discrimination. Thank you for the opportunity to testify today.
Thank you all. Thank you all very much for your testimony. Ms. Snow, do you know much about how other jurisdictions enforce language access laws?
I don't. I can get back to you with more information. I know that when I talk to other states, other SNAP advocates in other states, DC has much stronger protections in place than others. But again, we just don't have a means to enforce them.
Sure. And your top recommendations in terms of what we should be doing with enforcement?
I think the formal fine structure where, residents would be able to file a complaint, that complaint would move through quickly, the agency would pay a fine that would then go directly to the client. That would be the best structure.
Thank you. Ms. McConville, is the agency required to publicly report on a quarterly basis the number, type, and status of complaints filed by DOC employees within OHR?
I'm unsure if they're required to report on a quarterly basis. I do know they don't report them in a broken down way in their oversight responses. And so it's really hard to see what causes different sorts of complaints. I would like to note DOC did just settle a major lawsuit arising from a discrimination complaint related to LGBTQ status for one of their staff that would cost the district $500,000. So this whole issue creates a lot of financial strain on the district's budget.
Mm-hmm. Where was that settled? Which court or
I believe
body?
BC Superior,
Okay.
but I can send you the lawsuit.
Yeah. That would be great. Mr. Rigoni, you testified that the agency may not be doing enough to provide returning citizens public information on this issue, and you gave an example of a client experience. How does your client first hear about Ban the Box? And is there a statute of limitations on when he could file a complaint?
So there was not a meaningful statute of limitations that would have limited him. It was more in terms of the fact that by the time that he fully realized what was going on and what his rights were, he hadn't recorded the necessary things to feel like he could have properly gone forward. And it becomes one of those things to where when you're navigating reentry, it is a calculus of, is the time that it's going to take me to go through this process worth it with all the other things that I have to juggle to keep up with. In terms of how he first found out about it, he was generally aware of the notion of ban the box because that's talked about routinely even before you come out. However, it wasn't until I had a conversation with him when he was telling me about his experience about 3 weeks after he had applied and had this happen that I was able to start giving him more information that, what happened was potentially not in line with what the law actually protected him from.
Thank you for that. Ms. Butterworth, what was the agency's response when you brought up the mediation delays?
They're committed to working with us to refine internal processes and to an ongoing conversation. So we actually very much appreciate their response and openness and look forward to seeing where that goes.
What do you think is the underlying cause?
For the mediation, I think the underlying cause is sort of internal processes and training and refining standards for timely communication and scheduling. I do think that the cause of many of the delays that we see also relates to funding and staffing limitations and the need for greater funding.
Thank you. Thank you all for your testimony. All right, our next panel is virtual, completely virtual. It includes Rosalind Herndon, Managing Attorney, First Shift Justice Project, Susan McClanahan, Fair Housing Director, Equal Rights Center, Allison Miles Lee, Managing Director, Bread for the City, Deborah Shore, Executive Director, Sasha Bruce Youth Work, Vincia Sages, Public Witness, Patricia Stamper, and Kelly Mack. Great. We're going to begin with Rosalind. Yep. Go ahead when you're ready.
Good morning, and thank you to Chairperson Nadeau and members of the committee for the opportunity to testify today. My name is Rosalind Herndon, and I am the Managing Attorney at First Shift Justice Project, a nonprofit legal organization whose mission is to help pregnant and caregiving workers assert their workplace rights to prevent job loss. First Shift routinely represents individuals at the Office of Human Rights. First, I'd like to express how encouraged we are by the collaborative efforts between your office, Chairperson Nadeau, OHR staff, WHELA members, and other advocates that resulted in the passage of the Fairness and Human Rights Administrative Amendment Act. The Act brings changes that bear significantly on individual statutory deadlines, election of remedies, and for DC government employees, the damages that they are entitled to if they prevail. As such, it is incredibly important that sufficient and substantive notice is provided to complainants over the pendency of their case. Complainants' knowledge and understanding of this act is essential for them to understand and make informed decisions about how and in what forum to pursue their case and what damages to plead. Second thing I'd like to address today is, as First Shift has previously done, recommend the incorporation of the Protecting Pregnant Workers Fairness Act into the DC Human Rights Act. The remedies available to prevailing parties under the DCHRA are currently more expansive than those available under the PPWFA, especially with regard to compensatory and punitive damages. An incorporation would help ensure that victims of PPWFA violations are not deprived of the complete scope of relief that would make them whole. Incorporating the PPWFA into the DCHRA would also ensure that DC's law is in line with the Federal Protect Pregnant Workers Fairness Act and the broader scope of relief that is available under that law. The strengthening of the PPWFA is particularly important now more than ever, given the potential for federal rollbacks to the PWFA. Incorporating the PWFA into the DCHRA would also significantly improve the filing and intake process because it would obviate the need for two separate charge documents to be pursued. And lastly, I'd like to provide feedback on the attorney drafted charges program, which we understand is now in the process of being updated and will become permanent. This is very exciting news for those of us who routinely submit charges on behalf of our clients. One of the challenges, however, that we've experienced during the pilot program is the lack of consistency in terms of how different intake representatives treat the receipt of an attorney drafted charge. For example, in one recent case that I submitted an attorney drafted charge for, my client was able to bypass the intake interview entirely and get in the queue for mediation. Given the volume of cases pending at OHR and the length of time a complainant may have to wait for participation in a mediation, there is significant value in being able to get in the pipeline for a mediation immediately after submitting a charge, rather than after an intake interview and the receipt of finalized charges, as that process can take many months. In contrast, for another matter where I submitted an attorney drafted charge, the intake officer conducted an intake interview, which then resulted in the need to revise the charge. Over the course of the next 5 months, we did not receive any substantive feedback from OHR regarding the revised charge or the case status. For a complainant who was a victim of domestic violence and waiting for accommodations in the workplace, this 5-month wait to essentially start the complaint process left her feeling defeated and in fear at the workplace. After numerous inquiries, we were informed by OHR that rather than wait for her to edit the charge, for the intake officer to edit the charge, we could actually submit a revised attorney drafted charge. Notably, the revisions that she noted at this time were technical and not substantive, and the intake interview that had been conducted had no bearing on the required edits. Had these technical matters been raised upon the initial submission of the charge or shortly thereafter, I, as counsel, could have quickly resolved the issues and my client's charge would have been processed in a much more timely manner. Moving forward, as OHR prepares its permanent guidance on the program, giving attorneys the opportunity to make these necessary revisions to the charge, rather than have the intake officer undertake the revisions, would be an effective and efficient option to consider. Thank you for the opportunity to testify today. First Shift looks forward to continuing to partner with the Office of Human Rights to improve the ways that the office serves individuals who have filed complaints and hope to address and resolve discriminatory workplace conduct.
Thank you. Thank you. Ms. McClanahan?
Hi, good morning. My name is Susie McClanahan, and I'm the Fair Housing Director at the Equal Rights Center. The ERC seeks to eliminate unlawful and unfair discrimination in housing, employment, and public accommodations in our home community of Greater Washington, D.C. and nationwide. The ERC, as a complainant or non-attorney representative for complainants, has filed more than 50 fair housing complaints with OHR in the last 3 years. The ERC appreciates the opportunity to testify, and today I'll be discussing director's inquiries, delays in the administrative complaint process, and the attorney drafted charges program. First, the ERC has testified over the last few years to encourage OHR to file director's inquiries, which are a valuable tool to proactively address housing discrimination and reduce the burden on victims of discrimination. Recognizing OHR's limited resources, testing serves as a critical and immediate opportunity to open director's inquiries. The fiscal year 2021 budget included a $200,000 enhancement for fair housing testing, and over the last 5 years, the ERC has conducted such testing annually. We were thrilled to learn recently that OHR has filed 15 director's inquiries as a result of the ERC's testing, and we look forward to learning the results of these inquiries once the complaints have been resolved. Second, delays in the administrative complaint process appear to have worsened during the last 2 years, especially at the mediation and investigation stages. 18 of the ERCs and its clients' complaints were forwarded to the ADR unit in fiscal year 2025. On average, it took more than 5 months to schedule mediation for the complaints, with the 2 longest still pending since October 2024. Meanwhile, 20 of the ERC's clients' complaints have been in the investigation stage for at least 2 years, with a half dozen of those cases having been initially filed at the agency in 2022. These delays have real consequences. Many ERC clients have shared they relived the trauma of housing discrimination when asked to share their story over and over. Even worse, the delays can ultimately result in denied justice. One ERC client who filed her complaint in 2021 was shocked and distressed to learn last October that OHR was dismissing her complaint due to administrative convenience. OHR's basis for its decision was that the Office of Attorney General had brought litigation against the respondents named in her complaint, which included claims related to her allegations. However, the administrative dismissal notice failed to acknowledge complainant was not a party to the litigation and had no means to obtain any relief from the OAG's lawsuit. The ERC filed a request to reopen her case in November 2025 and is waiting for OHR to reach a decision. The ERC's client shared, "I could not imagine when I filed this complaint that I would find myself in such a hopeless position so many years later. I hope OHR will correct this wrong and allow me an opportunity to obtain justice." Recognizing the consequences complainants face from delays, the ERC is cautiously optimistic that delays at the investigation stage may finally be lessening, as the enforcement unit has recently been able to fill several vacant investigator positions. We also recognize that investigation delays are difficult to fully resolve without additional agency funding, given that the current number of investigators is insufficient to resolve the complaint backlog and timely investigate new cases. While the ADR unit would also benefit from additional staff, many mediation delays could likely be addressed with additional training and improved communication. The ERC also appreciates that leadership has been responsive when we have raised concerns, and we want to thank OHR leadership for recently meeting with us to discuss concerns about the mediation unit, and we are hopeful that ongoing collaboration will help streamline and improve the mediation process. Third, given the need for broad scope improvements to the administrative complaint process delays, the ERC appreciates OHR's innovative attorney drafted charges pilot program. Through the program, attorneys submit draft charges for their clients, and OHR then reviews and finalizes the charge for the complainant's signature. This can improve intake processing timelines because OHR staff do not need to conduct an intake interview of the complainant or draft the charge themselves. The ERC has heard positive feedback from attorneys who have submitted drafted charges during the pilot's operation from July 2024 through March 2025. The ERC is glad OHR plans to make the program permanent and issue additional guidance during fiscal year 2026. Lastly, while we have raised several concerns about OHR's performance today, we also want to stress the critical role OHR plays in enforcing the district's progressive civil rights laws. The agency has only been funded close to operational levels in the last few years and would still benefit from additional enforcement staff to help address multi-year backlogs. Any budget cuts would significantly hinder the agency's mission and make it more difficult for DC residents to meaningfully report housing discrimination. Thank you so much for this opportunity to testify.
Thank you. Allison Miles-Lee.
Good morning. My name's Allison Miles-Lee. I'm a managing attorney at Bread for the City. Many of our clients are limited and non-English proficient and rely on important government services to sustain themselves and their families. I'm also active in the DC Language Access Coalition, like Maggie Snow, who testified earlier today. I'm here today to stress the importance of passing legislation that will enable OHR to enforce the terms of DC's critical language access law, the Language Access Act of 2004. Councilmember Nadeau, you recently introduced a bill, the OHR Rulemaking Authority Amendment Act of 2026, that will accomplish just that. As you know, the council passed the groundbreaking Language Access Act to ensure that all district residents can access resources and services in the city, regardless of whether they speak English. The 2004 Act requires DC government agencies to provide interpretation and translation services. However, the only way to attempt to enforce the law is to file a language access complaint with OHR, which results only in a finding of noncompliance. Agencies are then free to disregard OHR's findings, and we have seen that they do. This is in stark contrast to the other discrimination complaints, non-language access discrimination complaints that go through OHR that can result in damages being paid out and other relief for complainants. Over the past 7 years, OHR has made approximately 28 findings of noncompliance involving at least 14 government agencies and contractors, including repeat violators. The violations are wide-ranging. There were also instances where agency staff engaged in disrespectful and humiliating behavior towards complainants, on top of the language access violations. Bread for the City is extremely grateful for the leadership and commitment of OHR's Language Access Director, Rosa Carrillo, and her team. OHR tirelessly investigates language access complaints, centering the community members' experiences and resulting in thorough reports. However, OHR has no power to enforce the law and cannot provide relief to complainants who have suffered harm. The new bill would borrow from the successes of other DC non-discrimination laws, such as the ban the box and employment and housing legislation, by allowing OHR to fine DC government agencies who are found to have violated the language access law, with the funds going directly to complainants. In addition to providing relief to those experiencing harm from their inability to access government services, we believe that the threat or use of a fine will induce agencies to actually take seriously their obligations under the existing law to develop language access policies, adequately train their staff, and provide language access services when necessary. When the DC Council enacted the Language Access Act, it wanted to ensure DC's diverse community could access government services. However, the desired outcome is not being met. Amending the act to give OHR additional powers to hold agencies accountable will help ensure that the original goals of the DC Council are met. Thank you.
Thank you very much. Vincia Salges.
Hello. Good morning. Thank you for the opportunity to testify. My name is Vincia Sages. I want to share my experience with the Office of Human Rights and the handling of my discrimination complaints. I contacted OHR for assistance in 2019, 2020, and 2022. Each time I was contacted and mediation was scheduled between myself and the other party. After mediation, I would not hear anything further for 1 to 2 years. Eventually, I would receive notice that my complaint was being dropped. On 2/2/2026, I received a determination regarding a complaint I originally filed in 2022, stating that the case was being closed due to no probable cause. This finding is deeply concerning given the seriousness of what occurred. I want to make it very clear that I did not file my complaint because of a simple landlord and tenant dispute. I filed because I believe I was discriminated against by the property manager due to being an African American woman with a housing voucher. I was awaking out of my sleep by strange men drilling holes into my door to gain access to the unit. Multiple unfamiliar men were sent to the property attempting to enter my home. I feared for my life and my son's safety. I had to call the police because I was terrified. I had been living in the unit for 2 years with a valid housing voucher. A notice to vacate is not the same as a legal eviction through the court process. I was not evicted by the court. I was forced and bullied out of the unit without proper court documentation. Despite this, OHR stated that I was occupying the property illegally. I submitted evidence, including video footage of the individuals attempting to break into my unit, yet I was told there was no probable cause. Being forced out of your home under these conditions after raising concerns about discrimination based on race and voucher status should not result in a dismissal years later without clear explanation. The repeated delays and the dismissals have made me feel that my case were not fully reviewed and that my concerns were not taken seriously. I am asking the council to examine how these investigations are conducted, why are there such long delays, and how the findings of no probable cause are determined in cases involving serious safety concerns and allegation of discrimination. Thank you.
Thank you. Ms. Stamper?
Good morning, Chairperson Nadeau and other members of the committee. So, Office of Human Rights, to me, they've never been helpful. I've been riffed, fired, laid off from DC government, DC public charter schools more than once for just doing my job. At a charter school, they can fire you for any reason. They don't have to really give you a reason. There's always on there, you can contact the Office of Human Rights to file a complaint if you feel like you were discriminated against. The same thing with DC government when I was riffed those 2 times. However, every time I contact OHR, it's pointless. I remember when I was pregnant with my first son, I contacted OHR, filed a complaint, did everything. And my son was born in July, and I filed the complaint in May. They contacted me like September, October of the same year, which was better timing compared to the last witness. But it's very disheartening to see that it's still the same stuff. And he's 10 now. And I was considering, like, I have a complaint against my former landlord who did not have a business license on the property from May of 2021 until 5 days till I closed on my home that I purchased in Ward 7. He literally enriched himself off of my money and my rent, but didn't have proper documentation to be doing business in the District of Columbia. Now, what are my legal ramifications? Can I sue him? No. Was I bullied by the property manager? Yes. Did this property manager used to be employed by DC government? Yes. Did this woman resign, Raynell Zapata, from DC government because she illegally evicted over 4,000 residents from public housing? And I found this out after researching her on Google and online? Yes. Now, was I bullied in the press? She was like, oh, well, what do you want me to tell the bank? Do you want me to tell the bank you've been paying on time? Or do you want me to tell the bank something that they may not need to know so you don't get your house? How do you think that made me feel, Councilmember Nadeau? Because it made me feel real SHITTY, because I'm going through all this, trying to be a good commissioner, a mom, provide for myself, take care of my mental health, and you playing with me about documentation with my lender? And this just happened recently. Like, I'm still considering what are my legal footing and the ramifications or what I could do. And I'm a commissioner. I'm pretty with it and know what to do. So it's very disheartening to know that the Office of Human Rights still, as a decade later, don't have their self together and can't support residents here in the District of Columbia accordingly. Thank you.
Thank you very much. Kelly Mack.
Good morning. Thank you so much for your time. I'm sorry, my building is having an alarm right now. It's just a test. Hopefully you can hear me okay. Okay, great.
I can hear you fine as long as you're safe.
Okay, all safe. I'm testifying today about my experiences with OHR. I live in Ward 3. I'm a power wheelchair user. And like most disabled people, I do not drive and I rely on public transportation, cabs, and rideshare. As you know, I've been advocating on cab accessibility for many years, and that includes filing complaints with OHR. I have experienced pervasive and repeated discrimination and denial of service by local cab companies refusing to provide accessible cab service. I have filed many complaints with the DC Office for Human Rights in order to seek redress. None of these complaints have resulted in any accountability or improvement in cab service. So in recent years, I've largely stopped filing complaints at all. The last complaint I have open was filed on September 26, 2022. I worked with attorneys from the Disability Rights Law Clinic at the American University. It has been a long and arduous complaint process, not at all simple for a non-attorney civilian. It's taken up a lot of personal time and energy. Last year, I was informed that I should receive a determination letter in January 2025. I still have not received a letter despite following up several times with OHR, and I keep being told that the letter of determination is not ready. This is a complete failure and is just an example of delayed justice for disabled people. In my experience with mediation, the mediator had no seemingly knowledge about disability rights laws and legal precedents. And I also felt the investigators I spoke with didn't have any training on disability rights law. This left me feeling very low about my prospects of justice. I've also found OHR to lack responsiveness and follow through on legally required timeliness and basic queries on status updates. I'm coming forward after many experiences of this kind, not just about these specific complaints, but other ones, that my perspective as a disabled resident, OHR hasn't really been helpful for addressing disability discrimination. Thanks. Happy to answer any questions.
Thank you very much. Thanks, everybody. So, start where we began. Ms. Herendeen, you testified that procedurally, when raising claims under PPFWA and DCHRA, Office of Human Rights currently requires complainants to file 2 separate charge documents despite the same underlying facts. Is that something you think the agency can fix under their rulemaking, or you think we need to do a legislative fix here?
Well, I think just by incorporating the 2 laws through either mechanism, having 2 charge documents, having that requirement be eliminated would be possible, just given the same underlying facts and how confusing it can be for complainants to try to differentiate between their claims under 2 separate laws.
Thank you. Ms. McClanahan, what kind of feedback have you heard from attorneys who've submitted draft charges under the Attorney Drafted Charges Pilot Program?
Generally, that it's been helpful and much easier to navigate the process rather than going through the intake process with intake interviews.
And Ms. Miles-Lee, your testimony revealed some concerning information on how some agencies have resorted to inappropriate ad hoc communication methods, such as using a child, relative, or fellow inmates in prison to communicate with people in place of trained professional interpreters. What type of enforcement provision do you think the Language Access Act needs for agencies not in compliance?
So as I detailed, I think there needs to be a fine structure. There needs to be something to make agencies prioritize this. Language access law is an unfunded mandate, and agencies, without any sort of enforcement, without having to pay a fine, they're just not putting their resources towards providing language access.
Thank you. Ms. Sages, I'm so sorry to hear about what you went through. Would you like us to follow up with the agency on your case to see why it was dismissed?
Yes, please.
Okay, we will follow up with you on that. And Ms. Stamper, also very sorry to hear about your experience, and we can certainly follow up with you on the options available to you as well if you'd like. Okay, great. Thumbs up. Okay, Ms. Mack, same offer, would like to follow up on your behalf if that's okay.
Sure. Thank you.
Sure, of course. Thank you so much to this panel. Okay, and we're going to now turn to our public witnesses regarding the Office of Contracts and Procurement. So that includes Jeremiah Lowry, Policy Director of the Coalition for Nonprofit Equity, Katie McConville, Policy Counsel with Council for Court Excellence, Iris Jacob, the Coalition for Nonprofit Equity, and Shelley Broderick, Chair of the District Task Force on Jails and Justice. If there is anyone else here in person who wishes to testify regarding the Office of Contracts and Procurement, now is the time. This will be our only panel on OCP before we move to our government witnesses. Give us a second till we get everybody up on the Zoom. Might be. Yeah. It is. Yeah. Hi. Okay. Did you want to go before Jeremiah or after Jeremiah? Let him go first. Okay. All right. So we'll start with Jeremiah Lowry.
So I have to go first, huh? Okay, I'll go first. Good. It's still morning. Good morning, Chairperson and members of the committee. My name is Jeremiah Lowry. I'm the Policy Director at the Coalition for Nonprofit Equity. Coalition for Nonprofit Equity represents nonprofits across the district, delivering housing support, behavioral health services, workforce development, violence interruption, and youth programming. Yet too often, their experience with procurement creates instability rather than partnership. Across our coalition, we consistently hear about delayed payments, contract renewals that take months, operating under short-term extensions, inconsistent communication, administrative bottlenecks. There's slow reimbursement from small to mid-sized nonprofits. These are not minor inconveniences. When payments are delayed, organizations struggle to make payment. Executive directors are forced to take out lines of credit to bridge reimbursement gaps. Hiring freezes are implemented. Staff burnout increases. In some cases, layoffs incur. These delays have real consequences. When nonprofits experience cash flow crises, residents experience service disruptions, youth programs reduce hours, behavioral health appointments are delayed, and housing stability efforts slow. Community trust is strained. I want to acknowledge that many OCP staff are committed public servants who do work hard to resolve issue. This testimony is not about individuals, it's about structural reform. The system must work consistently, not sporadically. Nonprofit service providers should not have to function as banks for the district government. They should not have to absorb financial risk created by delayed processes outside of their control. That's why I'm urging the council to mark up, vote on, and fully fund the Nonprofit Services Preservation Amendment Act and to strengthen oversight of the Office of Contracting and Procurement. We need clear guidelines, greater transparency, and payment systems that ensure nonprofits are paid fairly and on time. District residents rely on these services every day. A stable procurement system is not just simply a bureaucratic matter. It is a public service. Is for the public service. Thank you for this opportunity to testify. Before I cut this off, I think I got like maybe a few more seconds. Oh, I guess I got a little bit of time. Council members, I want to thank you for your leadership and moving the Nonprofit Services Preservation Amendment Act forward. Myself and the coalition partners are definitely looking forward to markup and getting that bill out of the DC Council, and as well as looking at ways that we could fund it. I know the budget is pretty tight, but hopefully fund a lot of pieces of it and come up with a strategy to fund the majority of it, all of it down the road. So with that said, once again, I want to thank you for your leadership of pushing that bill forward. We look forward to marking that bill up and getting it out the door. Thank you.
Thank you. Iris, go ahead.
Hey, can you hear me? Am I good? All right. Echoing what Jeremiah said about appreciating your work on this bill. Just want to start with that. Thank you. Chairperson Nadeau and members of the committee, my name is Iris Jacob, and I'm the director of the Coalition for Nonprofit Equity. I'm here today to urge you to mark up, vote on, and fully fund the Nonprofit Services Preservation Amendment Act of 2025, which many of the folks that have already testified would really benefit from overall. That's some ad hoc stuff. We know the DC region is already facing an affordability crisis, and nonprofits are being hit especially hard. Recent analysis shows that 43% of nonprofits in the DC area reported experiencing a disruption to their government funding, compared with 33% of nonprofits nationwide. When nearly half of our local nonprofits are seeing cuts, freezes, or delays in the government funds they rely on, it creates what the Urban Institute researchers have called a perfect storm. In a region where the cost of living is already high, residents need more support at the exact moment nonprofits are less equipped to provide it. The Nonprofit Services Preservation Act, B260249, is a necessary response to that reality. The bill would require district contracts and grants with nonprofits to pay for indirect costs in addition to direct service costs set at a 15% de minimis rate. This would align with federal standards and clarify that indirect costs must supplement, not replace program funding. It would also improve transparency and implementation by requiring clearer contract language, agency guidance, and training. You will likely hear questions about how much this bill will cost. The truth is that we do not have a clear answer because the analysis that was supposed to inform that conversation was never completed. When the original Nonprofit Fair Compensation Act passed in 2020, the fiscal impact statement required the Office of Contracting and Procurement to issue a report by April 2021 analyzing indirect costs for nonprofits contracting with the district, with the understanding that the Office of Revenue Analysis would re-estimate the cost of the law once the data was available. That report was not produced, so we're unable to answer how much it would cost. What we do know is that without payment for these true costs, nonprofits lose money every time they accept a district contract or grant. Chronic underpayment of indirect costs forces organizations to cut staff, reduce services, or close altogether, even as demand for their work increases. In a city where nonprofits are a major employer and a core part of the safety net, that is not just a nonprofit problem, it's a district-wide equity and stability problem. Given the scale of funding disruptions and the affordability pressures on DC residents, doing nothing is also a choice with real costs. Every year, we delay full implementation of the fair compensation for nonprofits. We push more risk onto organizations that are feeding families, keeping people housed, and supporting young people and elders. For the reasons I'm asking you today to mark up the Nonprofit Preservation Amendment Act, bring it to a vote this session, and then fully fund and implement it, including the relief grant program and the transparency and training provisions. Once the bill passes, we stand ready to work with you to ensure strong implementation and to continue advancing additional policy changes that strengthen the nonprofit sector and the communities we serve. Thank you for your time and for your advocacy.
Thank you very much. Okay. Why don't we go ahead to Ms. McConville?
Thank you, Chairperson Nadeau, for the opportunity to testify for the Office of Contracting and Procurement. My name is Katie McConville, and I'm Policy Counsel for the Council for Court Excellence. In the summer of 2024, on behalf of the Office of the DC Auditor, CCE supported an audit of 2 Department of Corrections facilities, collectively known as the DC Jail, the Central Detention Facility, CDF, and the Correctional Treatment Facility, CTF. The report was published last May and documented unsafe and deteriorating conditions, underscoring the need to move residents out of the aging CDF as soon as possible. CCE has also long monitored jail conditions and replacement efforts through facilitating the District Task Force on Jails and Justice. My testimony today focuses primarily on the food services contract for the DC Jail, expected to be solicited in 2026, and briefly addresses concerns about a potential contract for a new jail facility. First, under the current food services contract with Aramark Correctional Services, residents report inadequate portions, limited variety, and insufficient fresh fruits and vegetables. Residents and staff have reported food contaminated with inedible materials like bugs, as well as improperly heated food or cold meals being served. In a late 2023 survey, 62% of residents entering the jail ranked food quality as their top concern, and 58% of CTF residents identified food as the greatest issue in their facility. Despite consistent reporting about the poor quality and quantity of food in the jail, efforts to improve food offerings have not come to fruition, underscoring the need for OCP to ensure that higher quality and nutritionally dense food offerings are required in the next iteration of a food services contract. Section 32 of the Secure DC legislation was adopted in June 2024 to improve food services in the DC jail by requiring DOC to uphold nutritional standards and provide 2 servings of dark green vegetables, 2 servings of additional colored vegetables, 2 servings of fruit, and 5 ounces of protein-rich foods per day. However, Section 2 was never implemented because it wasn't funded. With a new solicitation forthcoming, we urge DOC, OCP, and the Council to require, at minimum, compliance with Section 32's nutritional standards. As members of the DC Jail Food Working Group, we also encourage Council to hold a hearing on the Food Policy Council Procurement Amendment Act of 2025, which would require values-based procurement for DC agencies, including the Department of Corrections. We further urge the Council to encourage broader vendor participation by removing any requirement that bidders have prior correctional experience in the upcoming solicitation. While vendors must demonstrate their ability to meet security needs, Aramark, the current vendor, has faced lawsuits in multiple jurisdictions alleging inadequate food portions in correctional facilities. In West Virginia, a pending class action lawsuit alleges residents are denied adequately portioned meals, forcing their families to spend money on food items from the commissary and care packages that they must purchase from the same company. Notably, Aramark does not provide commissary in the DC jail, but just as in West Virginia, it allows families to purchase care package meals for loved ones for $12 to $15 per meal through iCare, a company owned by Aramark Correctional Services, LLC. The audit also found residents relied on commissary because meals were too small. This is inequitable. The commissary lacks fresh produce, prices are high, and access is limited by housing classification in the jail. During the audit period, the food services per diem was $6.56, including labor, and that reflects the financial constraints likely contributing to poor quality and limited variety of food in the jail. With the jail housing 21 100 residents for an average length of stay of 271 days. It is critical that the next solicitation require healthy, adequately portioned meals through enforceable nutritional standards. Finally, we are concerned about the limited transparency surrounding the anticipated 2026 RFQ and potential RFP for replacing CDF, as well as a lack of meaningful community input into the process. We urge Council to include a community advisory board as a required deliverable in any planning, construction, or management contracts for a new facility. We are also concerned that prior design discussions indicated no outdoor access at all for residents. Access to outdoor recreation is a basic human need, and we urge Council to disapprove any contract for a new facility that fails to provide meaningful outdoor access. Thank you.
Thank you. Shelley Broderick.
Good noon, Councilmember Nadeau. I'm Shelley Broderick, and I'm testifying as chair of the DC Task Force on Jails and Justice, and nothing I say will be new to you. So forgive me, but I'm back. I want to address the likelihood that in 2026, the Office of Contracting and Procurement will bring before the council a contract to build a new jail facility to replace CDF. Since 2019, the task force has worked on to advance a humane and equitable approach to criminal justice in the district. We've consistently called for demolition of the DC jail's 50-year-old CDF and its replacement with a modern building designed with residents' safety, health, and rehabilitation in mind. The current facility, which houses more than 1,300 individuals, is in urgent need of replacement. As Katie said, the auditor's 2025 report documented persistent pests, recurring mold, plumbing failures, and design flaws that render portions of the jail unusable and create unsafe conditions for residents and staff alike. Despite years of calls to address these conditions, funding's been repeatedly deprioritized. In May 2025, the mayor removed funding for a new jail from the capital budget and announced that the district would seek a private firm to finance and construct it. We understand that the procurement documents, an RFQ and an RFP, are currently being developed. However, draft versions have not been released publicly, nor to my knowledge shared with the council, and there have been no public meetings on the planning or procurement process for almost a year. Why? What's up with that? Given that this building could be in use for the next half century and cost over $1 billion, transparency is essential. We asked this committee, as part of their oversight, to require OCP to make procurement documents public and subject to council and community review before any contract is approved. We also asked the council to require that the RFP and final contracts mandate the creation and maintenance of a community advisory board. You've heard me ask for this over and over again, and I hope you can help us. The Department of Corrections has said they are unwilling to create a CAB, but it's a National Institute of Corrections best practice to have community advisory boards. They've been implemented successfully in many jurisdictions, and they ensure that diverse stakeholders, including justice-impacted individuals, have meaningful input into the new jail's design, construction, and oversight. If DOC continues to oppose implementing a CAB, we ask the council and you, under your leadership, to reject any contract that doesn't include one, or to legislate and legislatively mandate its inclusion. Unfortunately, public meetings on the new jail's facility design to date have lacked details and transparency. Meetings have omitted key information, including the number of beds planned in each phase, the cell sizes, and the capacity for solitary confinement. However, we did learn that the current plans don't provide residents any access to outdoor space. Given that many individuals are held for extended periods, about a fifth of them for over a year, having no outdoor space for recreation is inhumane. As the nation's capital, the district has a responsibility to model what a modern, humane, and safe jail can be. We ask this committee and the full council to disapprove any contract for the new facility that's not been thoroughly reviewed by the council and the community. and that doesn't include a community advisory board, and that fails to correct serious deficiencies in prior plans, including the absence of outdoor space. Taking the time to get this right may delay completion somewhat, but it will ensure that this facility reflects the district's values and serves residents safely and humanely for decades to come. Thank you. I love any questions.
Thank you very much. Okay, let's start with our friends at the Coalition for Nonprofit Equity. How would you say that the passing of the Nonprofit Services Preservation Amendment Act of 2025 would change the current status quo and improve the process for nonprofits working with the district?
So I'm going to assume, I can't see Jeremiah, so I'm going to talk. Having this bill passed, having the indirect cost rate passed, and having it clear throughout all of the government contracting, because when we've done our research, we've seen that different offices are offering different indirect rates. So having clarity amongst the language, having all of that, it would help nonprofits tremendously, being able to pay their bills, being able to keep their lights on, being able to pay staff. One of the things that is really important about nonprofits in the district right now is that they are suffering more than other nonprofits in the rest of the country. And that is added with the fact that almost 70% of nonprofit staff are Black women. We add that with the rates of Black women losing their jobs. There's a whole epidemic happening right now, especially with the federal government. This would be huge for the city having this funded. And again, so many of the groups that have already testified would benefit from it.
Yeah, I was going to echo that. In addition, stronger reimbursement requirements, plain language for contract terms, as well as, there's something in there for potential relief and support for nonprofits during emergency times as well. It's a great bill, and of course, like Councilmember, you're an amazing champion for this particular bill, and it definitely would support a lot of mid-sized to smaller nonprofits throughout DC. So,
how have federal pressures impacted nonprofits in the district, and how would the nonprofit bill help relieve some of that pressure?
Federal pressure is huge. I would say I was just talking with a nonprofit yesterday around being scared around their DEI language and changing that with their staff, and how just all of the federal penalties, the money that was frozen for DC, all of these things have impacted. And I do not remember the second part of your question.
Oh, how would the bill help with some of that pressure?
Oh, it would be huge. It would cover those, the indirect cost that needs to be covered. And I want to echo what Jeremiah said about smaller nonprofits. Like this can be, I think larger nonprofits are seeing larger numbers. And so they're saying more about it, which is great. And our steering committee is made up of a lot of those folks, but we're also recognizing that a lot of smaller nonprofits are not aware of these rates. That's not clear within their contracting. And so having that just settled would allow for them to have the money that they need to do their programming and their advocacy work.
Okay.
Absolutely. Yeah, I was going to quickly say, as we know on a federal level, there's, delayed appropriations, constant shutdown threats. As we know, the COVID funds are, expiring and, reduced discretionary grants. And so it's like so many different question marks right now on the federal level. And just to have a fund, especially for emergency for nonprofits would be huge, as well as just like improving the system of getting funds to nonprofits in this particular time when the federal government is so unreliable, will have a major impact on smaller, mid-sized nonprofits. So
the only thing I would add to that is that the other money that nonprofits are getting is also going away. So it's not just the government, it's the foundations, it's the private folks, it's all of that. And the work that nonprofits are doing is critical to the city. Just wanted to add that piece.
Great. Thank you. Ms. McConville, from your perspective, where has OCP fallen short in structuring or enforcing the current food services contract?
I think there's several things that are just not known. The quality and types of meals that people are being served, particularly people with medical diets and other sorts of food restrictions, are often like completely homogenous. For example, when we conducted the audit, we found somebody being served broccoli for an entire day. And I don't think that I would encourage you to reach out to the DC food policy the DC Jail Food Working Group, which has members of the DC Food Policy Council
Mhm.
and the Good Food Purchasing Procurement, because they have a list of recommendations I know that they have given to OCP for this new contract that would remedy a lot of these deficiencies, and I'm happy to put you in touch.
Do you think OCP should incorporate performance-based penalties or incentives tied to food quality or safety inspections?
I think that would be amazing, because then at least we would have regular reporting and accountability within whoever is awarded the next contract, so that they know there is regular oversight that will occur. And that oversight currently isn't really happening. I'd also encourage, I know on the federal level, when there are BOP inspections, the food services places in the facilities are like literally taking photos of the meals, things like that. We don't have any sort of oversight in that nature.
You mentioned that outreach has been limited. Can you explain how the outreach has been insufficient and give any suggestions about what engagement standards OCP should require going forward?
Yeah, believe we were talking about limited outreach for the new jail contract. I'm working at CCE through the District Task Force in Jails and Justice. I have personally attended like 3 to 4 of the outreach sessions. I would say the Department of Corrections only advertises the outreach sessions if you fill out a questions and comments form on their jail planning website, which first of all, people don't know about. It's also not straightforward that the questions and comments form needs to be filled out to provide input or to be notified of these community engagement sessions. That notice is only given regularly 48 hours before the session occurs, often right at 5 o'clock when people end work. So I know there's very limited engagement. I also know I attended a session where DOC said they sent out over 10,000 postcards, but there was maybe 20 to 30 people in attendance, only 2 of which had received a postcard in the area. So in those ways, just the quantity and quality of outreach has been limited. But then also in those informational sessions, key details are omitted oftentimes. It took the task force months to get an answer on how many beds are planned in the phased construction approach, which was being used. Now that the district is seeking private financing, we have no idea if that phased approach is still going to be used with private financing or what oversight or accountability will look like. And so without key information being shared by the department of what the plans will actually look like, such as the lack of outdoor recreation space, we aren't able to substantively engage and provide recommendations. For example, nobody knows, there's always questions about what type of programming or medical services will be provided in an enhanced facility, and we have no information about that. So the amount of information and quality of details, and then also how DOC is conducting outreach could be improved to involve more people, especially people who've been in the DC jail and are experts on the conditions there.
Thank you. Ms. Broderick, how do you suggest OCP strengthen monitoring and compliance once a contract is awarded in this situation, like the jail?
Well, I think that I'd love to hear Katie's answer to that because she's a little more tuned to the details of it. I'd like to have real committee oversight as well.
Do you want to answer?
I'm
No.
frozen.
Sure.
I'm
That's
sorry.
okay.
Can you repeat your question?
Oh, yeah, I was just asking how, hold on, what did I ask? Oh, how do you suggest OCP strengthen monitoring and compliance once a contract is awarded?
One of the main ways is through this community advisory board, which as a national best practice, it's something that exists in the planning phase and then as oversight after the facility is constructed. And in my longer written testimony, I cited several places across the US who have implemented these sorts of boards for both jails and prisons being constructed. But with beyond just having a community advisory board, regular reporting on things that people don't have information about. So I think that's the number of people in the jail. Right now, I know DOC reports on a weekly basis, but then those numbers just disappear when the next week is reported. So that we can assess trends over time and assess improvements over time. But then also, I'm thinking of things that aren't reported on by other entities like CJCC. So things like, are people satisfied with the food quality? How many deaths in the jail have there been? DOC has way above national average of deaths in the jail from all sorts of different causes, but often those processes for once a death has happened, what the causes were, those determinations aren't made public. And I know there's a lot of things to be improved, but I would invite council to ensure that the community can provide all of the inputs and things that we need oversight on, so that we can continue to have it as this facility is constructed and after it's constructed.
Great. Thank you. Thank you both. Okay, I appreciate testimony from this panel. We're actually going to take a little break before we move on to our government witnesses. We're going to come back at 12:30. And at that time, we will be joined by the interim director of the Office of Human Rights, Elizabeth Fox Solomon, and the chair of the Commission on Human Rights, Motoko Ozawa. So everybody do what you need to do. We'll come back at 12:30 and we're going to power through both agencies. So thank you so much. All right, and we're back, and we have been joined by our friends from the Office of Human Rights and the Commission on Human Rights. And I assume, Director, that you'll introduce everybody who's with you, but before we do that, ask everybody to raise your right hand. Do you swear or affirm under penalty of perjury the testimony you're about to give to the Committee on Public Works and Operations is the truth, the whole truth, and nothing but the truth? Yes. Okay. You may begin your testimony. Whoever's going first. Madam Chair, are you going first or Director going first? Okay. We can go, we can do one after the other and then we'll go to questions. Great.
I am Elizabeth Fox Solomon, Interim Director and General Counsel of the Office of Human Rights. Thank you for the opportunity to testify about OHR's performance and priorities for fiscal year 2025 and 2026 to date. This is a pivotal time for civil rights in the district. Across the country, we are witnessing the rollback of protections that generations fought to secure. As federal agencies retreat from civil rights enforcement, more and more residents are turning to OHR for help. The DC Human Rights Act of 1977, one of the most comprehensive civil rights laws in the nation, protects against discrimination in workplaces, housing, schools, public accommodations, and government services based on 23 traits. OHR enforces the Human Rights Act and 14 other local laws. Our mission is to eradicate discrimination, advance equal opportunity, and protect human rights through enforcement, outreach, and proactive compliance. Despite a very challenging year, OHR delivered measurable results for the district. We strengthened operations by onboarding 14 new staff, including key leadership and enforcement roles, and we are on track to fill all approved vacancies by this April. We invested nearly $400,000 in goods and services from small and local businesses, surpassing our certified business enterprise goal. And we secured significant monetary and public interest relief through our enforcement work. Education, outreach, and compliance are central to our mission. In FY25, OHR engaged residents across all 8 wards, deepened partnerships with trusted community organizations, many of which testified here today, and developed resources to help people understand their rights, including a new source of income and housing poster, an employment resources toolkit, and a campaign to highlight protections for our unhoused neighbors. Our Creating Safer Spaces team educated residents and trained more than 3,000 long-term care staff on inclusive practices for LGBTQI+ seniors and seniors who are living with HIV. We also enforced workplace protections in the tipped wage industry, delivering training to over 350 businesses and thousands of workers on preventing and addressing sexual harassment in the industry. Our language access program advanced equity for residents with limited or no English proficiency by expanding multilingual phone and digital access, providing guidance to agencies adopting AI-powered language tools, and increasing engagement with ANCs. Finally, the Youth Bullying Prevention Program reached tens of thousands of students, parents, and teachers, contributing to safer learning environment for the district's children. OHR's Returning Citizens program partnered with the Corrections Information Council to inspect the district's central detention facility following an auditor's report with concerns about resident treatment. The review focused on language access compliance, environmental health concerns like mold, and conditions within the central cell block. OHR met with CDF staff and residents to evaluate practices, identify compliance gaps, and drive accountability and system improvements. Enforcement, of course, remains the core of OHR's work. Last fiscal year, we secured more than $1.1 million for victims of discrimination through mediation, conciliation, hearings, and enforcement actions. The agency exceeded its case resolution goals, resolving more than 80% of FY23 and older cases and 58% of FY24 cases. We also conducted a record number of mediations in FY25, securing over $700,000 for complainants. And we initiated 15 directors' inquiries to investigate source of income discrimination in housing. OHR's public interest litigation continued to drive systemic change across the district. OGC attorneys litigated 23 probable cause cases before the commission and negotiated 12 voluntary compliance agreements, recovering over $425,000 for complainants and securing public interest remedies such as training, notice posting, monitoring, and policy changes. But sustaining these successes will require continued investment. Demand for OHR services is surging. Last fiscal year, we received over 1,300 complaints and docketed 430 new cases. So far in FY26, we are averaging 100 new complaints each month, and we have more than 1,000 open cases, including over 400 awaiting mediation, which we heard about earlier today. It's important to note that this workload is managed by just 5 intake officers, 2 mediators, and 8 investigators. And these are not just numbers. As we heard from the public witnesses who testified today, and as I can attest on behalf of my staff, behind every case is a DC resident, student, worker, or visitor who is seeking help, and our staff are stretched beyond capacity. We are so grateful to Mayor Bowser and the council for funding additional enforcement unit positions. And just last week, we welcomed 2 new investigators and an intake officer, and a new assistant will join the ADR unit later this month. I am also pleased to report that OHR's hearing unit, which supports the Commission on Human Rights, is on track to be fully staffed by the end of this quarter. We recently welcomed a chief administrative judge, and we will be onboarding a second judge and a permanent legal assistant soon, thanks to the council's FY26 budget enhancement. Looking ahead to FY26, our priorities center on 4 key areas. First, we will seek to strengthen operational capacity through targeted hiring and retention strategies. Second, we will work to improve service delivery by refining intake, investigation, and ADR processes to manage rising case volumes. Third, we will continue to deepen engagement with communities most impacted by discrimination. And finally, we will continue modernizing our technology by implementing a new case management system to improve data integrity, reduce administrative burdens, and deliver better and more transparent service to the public. In closing, I want to express my deep appreciation to OHR's dedicated staff for their professionalism, their commitment to public service, and their resilience under extraordinary pressures every single day. I also extend my sincere thanks to Mayor Bowser, Deputy Mayor Appiah, Chair Nadeau, the committee, and council for your continued support of our work. Finally, I want to thank our community partners, many of whom were here today, who bring forward concerns and suggestions that help us improve and better serve district residents. We could not do this without you. Together, we can ensure that the district remains a national leader in protecting and advancing human rights. Thank you so much for the opportunity to testify today, and I welcome your questions.
Chair Zawa.
Good afternoon, Chairperson Nadeau, committee members, and staff of the Committee on Public Works and Operations. My name is Motoko Aizawa, Chair of the District of Columbia's Commission on Human Rights. Thank you for this opportunity to discuss the activities of the Commission in fiscal year 2025 and fiscal year 2026 to date. The Commission on Human Rights has 2 functions. First, to serve as a body to adjudicate complaints brought under the DC Human Rights Act, and second, to help promote awareness of the human rights protections afforded by the Human Rights Act. You are already very familiar with these functions, so I will describe them only briefly. The Commission is a quasi-independent administrative body that is affiliated with the Office of Human Rights. The Commission currently consists of 10 commissioners, appointed by the mayor and confirmed by the DC Council. The Commission, together with the administrative judges or AJs in the hearing unit, provides administrative relief for violations of civil rights laws that occur in the district, most notably under the Human Rights Act and a host of others. If OHR finds probable cause of discrimination following investigation and conciliation has failed, cases are certified for a public hearing before the Commission. Before proceeding to a full evidentiary hearing, the AJs issue a scheduling order under which the parties exchange discovery, following which they may file motions for summary judgment. The presiding AJ then conducts a full evidentiary hearing as in trial, except for a few distinctions in formality and parties' burden of proof, for example, and parties are afforded opportunity to present evidence and witnesses. After the full hearing is completed, the AJ assigned to the case will request a tribunal of 3 commissioners to review the case, and a final order is prepared by the AJ. The tribunal then meets to discuss the case and either adopts, amends, or rejects the proposed order. Once the decision is finalized, it is issued to the parties. The Commission meets bi-monthly to be briefed on developments, including status reports on cases pending with the Commission, updates from OHR and various committees of the Commission, and any other activities. We periodically receive training to stay updated on changes in relevant DC laws and regulations and other developments. In addition to this adjudication role, the Commission has another important role, which is one of education and outreach to help raise awareness of the benefits of the Human Rights Act in the communities in which we live and work. As you are aware, through most of FY25, as was the case in FY24, the Commission was hampered by many vacancies and only just managed to meet the minimum level of activities under each of the 2 Commission functions. But we are happy to report that our situation is finally turning around. Just a month ago, we were able to hold a Commission meeting with 10 commissioners, 6 of whom were just confirmed and sworn in. A permanent chief administrative judge recently joined the hearing unit, and a legal assistant will be joining soon, supported by the Council's FY26 budget enhancement. With these changes, we are finally able to set our sight for the rest of the FY26 to onboard the new commissioners and ready them to serve on tribunals as quickly as possible, fill officer vacancies, make committee appointments, set other priorities, and plan our engagement in the communities around us. This turnaround is in no small part due to this committee's steadfast commitment to protecting and enhancing human rights in the district. And we are deeply grateful to the office of this committee and especially the committee chairperson for your continuous support. The Commission has yet to establish its detailed priorities in FY26, but in furtherance of the Commission's 2 functions, we expect our priorities to continue to focus on the efficient and effective adjudication of complaints and outreach activities that would include, among other things, organizing the Commission's annual Human Rights Awards ceremony. On efficient and effective adjudication of complaints, notwithstanding the challenges we experienced, the Commission managed to close 12 cases in FY25 and 2 cases in FY26 to date, which are all private sector cases, in addition to managing 2 appeals. I am deeply thankful to our veteran commissioners, reduced to 4 before being joined by the incoming 6 commissioners, for having endured a record number of tribunal assignments. They were always available and willing to roll up their sleeves again and again to help keep the cases moving. We could not have achieved the case closures without them. Turning to the rest of FY26, we expect to carry out our adjudicatory responsibilities at the same or improved pace, subject to the year's caseload. To reach the Commission's statutory membership limit of 15 and insulate the Commission's duties from the impacts of future resignations and non-renewals, we hope to recruit 5 additional commissioners. We also expect to revive the work of our 3 committees, especially that of the Rules Committee. This will allow the Commission to contribute to OHR's ongoing efforts to enact the rule changes necessitated by the Fairness and Human Rights Administration Amendment Act of 2024. On our outreach activities, we expect to reconstitute the outreach committee and organize a few awareness raising and educational programs centered on the Human Rights Act in various parts of the district in collaboration with OHR. Again, the centerpiece of the Commission's outreach will be our annual Human Rights Award ceremony, expected to take place in December 26. I would now like to spend a few minutes to tell you about the Human Rights Award ceremony that took place last December. This ceremony was dedicated to the memory of the late Honorable Chief ALJ Erica L. Pearson, who passed away in July 2024. To honor Chief Judge Pearson's advocacy for human rights, especially for women and children throughout her career, our ceremony recognized individuals and organizations for their outstanding service to women and children in the district with several awards, including the newly established Erica L. Pearson Award. This year's awardees were Miss Fatima Goss Graves for the Cornelius Neal Alexander Humanitarian Award, Miss Brittany Mobley, who received the Erica L. Pearson Award, Mrs. Vernice Tejeda, Mecca Bay, and Maya Burkhart, all of whom received the Emerging Leader Awards, and the Zonta Club of Washington, D.C., which received the Community Service Award. The Commission partnered with Georgetown Law Center's Street Law Program, a longtime co-collaborator with the Commission, to also recognize students who helped advance civil engagement and human rights through legal education. Over 100 guests enjoyed the evening of testimonies and celebrations. Our heartfelt thanks go to Georgetown University's Street Law Program for the use of Georgetown Student Center venue, as well as our ongoing collaboration, to OHR for the budgetary and personnel support to make this event a success, and to Councilmember Robert White, who delivered a deeply moving statement honoring the late Chief Judge Pearson. In closing, we are pleased to start a new chapter in the Commission history book with a fuller roster of commissioners and a fully staffed hearing unit, leaving behind some divergence of views with OHR that existed over the last few years. We recognize and appreciate the steadfast support we have received from this committee to help us reach this new chapter, and hope that we may continue to count on your support as we move forward with our new priorities and activities. We greatly look forward to working with the newly staffed hearing unit and the interim director and staff of OHR to achieve and exceed the full potential of the Commission in the remainder of FY26 and beyond. Thank you for your attention, and I'm happy to answer questions.
Thank you. We'll start with the chair here. Chair Ozawa, is the commission currently operating at full capacity?
So as I mentioned, we can go up to 15 commissioners. We are now up to 10, thanks to you for moving the process forward. We do intend to recruit 5 more this year to reach full capacity. We currently do not have 2 officers, but we intend to hold elections in March so that all those positions should be filled. And as I mentioned, we intend to reconstitute our committee meetings. So with that, that is our full capacity, and I hope we achieve that within this fiscal year.
Will you be running for chair again?
Actually, my appointment as commissioner has expired in December, and I have asked to be reappointed as commissioner. And if appointed as commissioner, I would like to run as chair for another term.
Can you run for chair in March if you haven't been appointed yet?
So there is normally a, the chair position is actually nominated by the mayor's office.
Oh, right.
So it's not subject
That's
to
not
election.
on the,
Yes.
I get it.
And we usually have a 6 months grace period for commissioners whose terms run out, but who would like to be reappointed.
Okay. You were so focused on getting those seats filled that you didn't tell me we also needed to get you reappointed when we were doing all that. So here we are. Okay, we'll figure that out. There seems to be high turnover due to resignations and non-renewals. What do you make of that?
So I would say that the number of resignations and renewals we have experienced over the last few years is pretty much normal.
Okay.
Because people move, people have new jobs, people get busy, and people decide they had enough after 1 or 2 terms. We do have those turnovers. What we have experienced is nothing abnormal.
Okay.
It's just that those positions should be filled as we create those vacancies. And that had not happened for 3 years, I believe. And so that's where we got tripped with so many vacancies.
What about the midterm resignations? Is that typical?
No, I don't think that that is anything unusual.
Okay. Okay. All right. Now, you noted that in your pre-hearing responses that due to the vacancies in 2025, the commission was forced to suspend some activities in order to focus on its adjudicatory function. What specific activities were suspended that you'll be able to bring back now?
Yes, so we first of all wanted to really make sure that our adjudicatory function is performed. So that was the priority. And so what took the hit was basically our outreach side. And other than we were able to organize the Human Rights Awards ceremony, which got delayed, but we did manage to hold that last December. But in addition, we usually do participate in other outreach activities, usually in collaboration with OHR. We had no one to spare to attend those events this year. And so it's the outreach side that took the hit. And also the Rules Committee was not simply constituted. We just did not have enough people to serve on the committee to make a meaningful impact. And so those two things I would say are the most significant areas from which we were absent.
What does a sustainable staffing model look like at the commission?
Well, if you mean staffing model for the hearing unit, I think that we are going to have to experiment how the hearing unit as it is currently envisaged to be staffed will work out in the coming months. So we do have our new chief, AJ, who is sitting behind us. We are so very, very pleased to have her on board. She only joined us less than a month ago, so this is why she's not part of this panel. We will fill or reconfirm another AJ position. And as we mentioned, there is a legal assistant who will be hired, who should come on board fairly quickly. We have made a case for a third AJ in the past. We will have to see how the current staffing will work out in the coming months. It may be that the staffing model will be 2 AJs plus additional assistants, legal assistants or paralegal type positions to help relieve administrative tasks of the judges. So we are going to keep our minds open. And that's one of the things that we will collaborate very closely with OHR to figure out going forward.
Great. So in the past, we've had conversations about the classification of ALJ salaries, the ALJ classifications and salaries. And I think the commission has had a slightly different opinion on that than the agency. Do you agree? You haven't quite been on the same page?
Yes, I agree.
Okay. What was the outcome of the most recent OHR review of classifications and salaries, and what's the commission's view on that outcome?
Right. So first of all, I went back to all my oversight statements, and I said this every year over the last 6 years, that there have been a perception that AJs have not been compensated appropriately, in part due to the way they are classified. And so the issue of compensation is connected to the issue of classification, whether the AJs are considered to be on a legal service track or career service track. And whichever way we went had in the past, we have had several different iterations of this. I am very thankful to OHR for finally taking a very, very close look at the classification issue. And I will defer to Interim Director Fox Solomon to go through the details because this is the OHR investigation. But I know that they have also involved DCHR and went through the history of the classification and the different ways in which judges were classified and why. And so I am grateful for the thorough investigation. I now understand where we stand. And I also know that because we have a new hearing unit, we will basically drop this issue, and we are satisfied with the way in which they are classified. And we just look forward to putting this issue behind and having an excellent relationship with our AJs and OHR.
Director, do you want to speak to that process and conclusion now?
Happy to do that. So thank you. Yes, that was an issue. You know, I was named interim director in July. And one of the first things I did was to meet with Chair Azawa and to meet with our hearing unit staff and to really try to figure out what were the barriers, what were the issues from their perspective, so I could figure it out, because I knew this had been a longstanding issue. When I was applying for the job of general counsel last year, I watched the oversight hearing as I was in the interview phase and heard the testimony. So I wanted to figure it out. So I did go back through the history, you know, of course, the statute and the regulations, but also the history I could find of past classifications of the unit. The statute refers to the hearing unit staff as hearing examiners. So that was the initial classification, was hearing examiner. And those are career service positions, grade 11 to, I want to say 12. There were complaints about lack of compensation at that point in time. And so they were reclassified as management supervisory service for the chief and as career service at a higher level, a grade 14 for the second judge. Years later, there were additional concerns about compensation. And so the unit was reclassified, as the chair mentioned, to legal services. Legal services have a slightly higher pay scale than career service or even managerial at times. But we were told later, I understand, and this is in the statute, I researched it as well, that you can't be a legal services position if you hear cases. So that was an improper classification, we were told. So it reverted to the MSS 15 and the CS 14 for the two judges, and that's where it stayed. So after doing that research and following up again with DCHR, I also looked at, you know, the hearing unit had provided comparators. They compared themselves to Superior Court judges, to Maryland court judges, to ALJs at OAH. And so I looked at those, obviously judges, that's it's a different classification system, but I did look at OAH and some other agencies that have hearing examiners, and it's a wide range. There are a lot of folks classified as hearing examiners who are paid less than our staff. There are a few ALJ positions that are paid more. Those ALJ positions are executive service, accepted service classifications, which do not have job protections and their terms and their specific qualifications. And so ultimately the conclusion was they're properly classified, and we have a wide range of compensation within the classification. And so I committed to make sure the compensation is appropriate for the folks, not just looking at to me, it was important to not just look at other judges or AJs at other agencies, but our own staff, because we want pay equity within the whole agency. So most of our managers, just by way of comparison, most of our managers are 14s and 15s, which is what the hearing unit is. So after that classification and compensation analysis, I think we feel very comfortable that that is appropriate. We're always happy to look if there's something we missed, if there's, you know, I want to advocate for more funding for all of our staff. We have a lot of folks who are working really hard and not getting paid as much as federal counterparts, or in some cases counterparts at other agencies, but I am satisfied that we are at the appropriate level for what the work is.
Thank you. Okay. Madam Chair, in addition to monetary damages, the commission has ordered in Q18 in the question 18 in our responses, what kind of non-monetary relief was also provided in cases adjudicated?
So normally I would defer to the AJ to answer this particular question.
Okay.
Would you like to do that? Thank you.
Sure.
So my understanding is that most of the cases that were resolved in the last fiscal year were resolved through voluntary compliance agreements. So they were settlements. So I touched on that a little bit in my opening remarks, but the public interest relief that we secured through the voluntary compliance agreements were things like policy changes, training, monitoring, and reporting requirements to the agency. And I think there was one case that was a finding with damages. So that was both monetary damages, and I think the injunctive relief in that case was similar, some training and policy changes.
And how does the commission follow through on non-monetary relief ordered, such as trainings, reporting requirements, or policy changes?
Sure. So with things like voluntary compliance agreements, those are negotiated by our Office of General Counsel. And so if we receive information, usually from a complainant, sometimes from a respondent, that our orders are not being complied with, we follow up. So we follow up through a letter process, and then we have further enforcement steps we can take. And same thing would go if someone violated an order of the commission, we would also work to enforce those orders.
Have we had, oh, go ahead, yeah.
Excuse me, we have one example of how we follow up in our answer to question 21. So-
Okay. Oh, very good. Thank you. And have you experienced issues with different district agencies complying with these agreements?
I'm not aware of any district agency that we've had an issue with compliance with an agreement, but can you think of any, Chair?
No, I'm not aware of an example. We did go through the Department of Licensing and Consumer Protection for one case that required enforcement. This says OHR did not receive any response from these agencies, and so I think it's a case by case.
So DLCP could be one area of follow-up.
That could be an area of follow-up. We also do have our interim general counsel who litigated a lot of these cases. So if there's anything, is there anything you want to add or? Right. Yeah, she just wanted me to clarify the VCAs, the voluntary compliance agreements, those are private sector cases. They're not with these agencies.
Okay.
Yeah.
Got it. Okay. Got it. Okay, and Chair Ozawa, are there any ongoing barriers generally that can be addressed either by this committee or the council as a whole?
Right now, no. Thank you so much for your support up to this point. We just have to now get down and do our work.
Wonderful. Thank you very much for your testimony. Okay. Director, can you describe for the committee some of the major activities carried out during fiscal year 25 and the accomplishments of which you are most proud?
I think that I'm most proud of the resilience of our staff. As I mentioned earlier in my testimony, our staff face some pretty crushing workloads. They face many members of the public who are very understandably frustrated. It's heartbreaking to hear the stories of people who testified today. Those stories are unfortunately not unfamiliar to every member of our staff. And at times, the frustrations of the public turn into slurs directed against our staff, threats of physical violence, really abusive language, and that takes a toll on our staff. So I'm really proud most of our staff for banding together this year in a really tough year. We had a hiring freeze, as you all well know. We had to, not fill certain contract positions. So we were really struggling. And so one thing that came out of that is we have really worked to work across teams. So we detailed an attorney for 2 months to the ADR unit to help with backlogs there. We have folks who are cross-training. We have managers who are stepping in and doing intakes. We've really worked across the board to try to do what we can to help with these issues as they arise. So I think that would be a very significant accomplishment. And then the $1.1 million for victims of discrimination, I think we had 885,000 in our written remarks, and we realized we were missing a whole category of our voluntary compliance agreements. And so I think returning that money, it's really returning money that belongs to our public, right? It belongs to our students, it belongs to our employees. And so returning that money, and then also in each case, making sure we have that public interest relief. Those changes, the things that help everybody, not just the individual who has the courage to bring the complaint forward.
You mentioned in your testimony that as federal agencies retreat from civil rights enforcement, more residents are turning to OHR for help. Can you elaborate on how that's occurring?
Sure. So, federal agencies, it's not surprising, have different priorities. That happens with every administration. And so as we see our major federal partners, like the Department of Housing and Urban Development and the U.S. Equal Employment Opportunity Commission, have changed the types of cases that they are prioritizing, certain cases that they are no longer accepting. So as we see that, and then we also see people who are afraid to go to the federal government, our immigrant and migrant workers who are afraid of their information being in a federal database, our LGBTQI plus population who has concerns about some of the statements coming out. And so more people are coming in our doors and they're saying, we want to file with you. We do not want to cross file with the federal government. And so we're seeing it really in terms of increased case volumes, but also groups of people asking to opt out. And that's a problem because it means they're losing their federal rights. And they're only able to pursue under district law. And many people who come to us have causes of action under federal and district law, and they should be able to pursue both of those.
Thank you. All right, I want to just shift into some sort of basic info about the agency. How many FTEs total are at OHR?
So we have 80.5 FTEs.
Okay. Last year, you had 9 frozen positions. This year's response showed 21.5.
Right. So of the 80, I think the easiest way for me to remember it is we only have 53 people working for our agency. So 80.5 is the FTE count, but 27.5 of those positions are vacant. 21.5 of the vacancies are frozen.
Is that more? I mean, is my number from last year 9 correct? And now you have more frozen than you did last year?
Do you know?
That's correct.
Okay, this is our Chief Administrative Officer, Ayana Lee. I should have introduced her.
Nope.
Hi, Ms. Lee. Good to see you.
Good to see you as well. Yes, that number is correct. It was 9 from last year.
Okay. Any understanding of why your number of positions frozen increased?
Yes, I mean, the number increased because we have to meet a vacancy savings rate each year district-wide, and we also need to meet a mark with respect to the budget. So because our agency is predominantly personnel, we do not have a very large non-personnel budget. When we're asked to make cuts, unless I fire staff, which I am not going to do, it means we have to freeze positions.
Okay. Do you have 2 housing investigator positions frozen right now? Is that right?
No, so I'm happy to report that we have, for the first time in many, many years, we have 3 full-time investigators on our housing team. One new investigator just started a couple weeks ago. The other one started, I think, over the summer. And historically, we've had 2 investigators in the green team, which is our housing team. It was down to 1 for most of FY25, and now we have 3, and we also have 2 intake officers who are specifically housing, which is up from 1. So I see really good things on the horizon for the housing team. It's going to take Our training program takes a long time because we need people to understand all of the different statutes and our processes. But once they're up and running, I think we're going to see a dramatic improvement in the processing of our housing inventory.
Great. Love to hear that. Are there any federal contracts that you're concerned about being cut?
We're not concerned at this point. We're awaiting contracts from our federal partners. So I think that's a wait and see and hope that the long relationships we have with those agencies will continue.
Okay. And what divisions are those in?
That would be HUD for our housing and EEOC for our employment cases.
Okay. Can you give me an update on the implementation of the new case management system?
Sure. So the case management systems is still we were in the planning phases last year. This year, we're in the sort of pre-implementation phases. So we've, because of the number of statutes, each statute requires a different complaint form and a different workflow. So our Associate Director of Enforcement, Amanda Schlenner, who I should have introduced earlier, she has been working very closely with the senior advisor in the director's office and some staff in our attorney's office to figure out how those complaint forms are going to work, make them compute into automated processing. And then we're working on system build out and data migration. One of the issues with our agency has been that we are predominantly a paper agency. We have paper files. Because we don't have a functional case management system, we rely on a series of spreadsheets and double checks and emails and calendars. And so trying to get all of that into one system so that we can properly track cases, report on them, that's the goal. And so I don't know timelines yet, but we're actively going to migrate data soon. And then that's the big next step before the build out of the system.
And what's Octo's role been?
Octo has representatives who've been joining the phone calls that we have. We have weekly meetings and phone calls with the developer of the system. So they've been helping us through all of those meetings and then helping to translate the tech for our folks who just don't have that technical background.
Okay. A couple follow-ups regarding the agency statutory mandates. For the Open Movie Captioning Requirement Act of 2024, have there been any other audits besides the first one?
Yes, we've had 3 audits. We do it by calendar year, not fiscal year. So there's been 3 total audits. The most recent one was in December. We try to time them with a big new blockbuster release, a Spider-Man or something along those lines. And every audit, we've had 100% compliance. So that's been a huge win for the district because we've realized that there are many people who appreciate captioning, not only folks who are deaf or hard of hearing, but many people who appreciate it for accessibility, folks who are neurodivergent who appreciate it. So that's been a tremendous success.
Excellent. With respect to the Fairness and Human Rights Amendment Act, have you hired an investigator yet?
Yes, that is the one position that is not frozen, is we got the investigator for fairness.
Great. And when does the agency plan to begin adjudicating complaints for the Second Chance Act?
Second Chance Act went into effect October 1st when it was funded. So the first thing we did is get a complaint form on our website. It's translated into the 6 languages. And so we have not received, I just checked because I know a witness asked about it. We have not received any complaints yet, but we'll certainly monitor to see where we are with those.
Great. And have you hired for the enforcement positions yet?
I believe all the second chance positions are frozen. So we have, shifted the work around all of our investigators.
Okay. The committee received an uptick of complaints from residents regarding scheduling issues in the mediation unit, either no reply or incorrectly leaving out necessary parties to a mediation session, which resulted in significant delay, especially for pro se litigants. Can you explain what's been going on there?
Sure. Yeah, that's been a very challenging issue. So we're kind of working on it through several fronts. As one of the community members mentioned, we've been meeting with our community-based partners to kind of really hear what it looks like from their side of things, because we understand where we're having issues internally, but to hear from, each step of the process where there are potential bottlenecks so we can, attack each of those. Of course, some of it comes back to staffing. We have 2 mediators, 400 cases pending mediation. The scheduling issue, our scheduler position has been vacant since summer of 2024. So that's a barrier. We've relied on contractors and tried to work on that, but I'm pleased to report that we do have a full-time permanent administrative assistant joining the ADR unit Monday. So we will be welcoming her. So that's personnel. Processes, we are trying to figure out how to do this better. So we've engaged our partners at different agencies. We've engaged Octo to try to figure out, is there a multi-party scheduling tool that we can use? Understanding that there are going to be some people who tech is a barrier, but for many people, having a tool that you could select on a calendar and schedule a mediation rather than emails, follow-up letters, phone calls. The multi-party nature has been the barrier because especially in housing, you often have 4 respondents, right? You have a property manager, you have an owner, you have an agent. So getting all those people to agree on a time and show up is a massive barrier. And then we have people who dodge us, right? We try to schedule a mediation, they ask for extensions, they don't respond, and then we're chasing them down. So we're fully aware of all of the issues and we're kind of working through the bottlenecks at each of the stages to see how we can improve. We know it's a problem.
Do you see anyone in other states doing it in a way that's you'd want to emulate?
I've reached out to my, former partners in New York to see if they had any suggestions, and most agencies look like they're doing it the same way we are, which is sending out a letter with a date. Most of those agencies, though, have voluntary mediation, not mandatory. So I think that eliminates the barrier of people who are not showing up because you're agreeing to mediate the case. Both parties are coming, so it's smaller volumes. But I'm not giving up. We're going to figure this out. Amanda has been working incredibly hard as the enforcement director to figure this out, and we're going to keep working on it.
How many complaints on average is an investigator assigned to investigate at a time?
So our investigators have a caseload of about 40 cases per investigator, and that's just our tenured investigators. Our new investigators don't have a full caseload yet. And then we have, this was alluded to earlier from some testimony, we do have cases that are unassigned. And that was a decision we made because, giving an investigator 80 cases, 100 cases is demoralizing. It's crushing. And so we do have cases that are unassigned, waiting for them to resolve cases, and then we'll assign those cases.
Okay.
And then our intake staff have about 100 cases or inquiries on their dockets each.
Are there any categories of complaints that process faster or are slower than others?
Not specifically. I mean, I think one thing that does make cases take longer is if there's multiple statutes and multiple issues. Protecting Pregnant Workers Fairness Act was raised earlier, and because that is a separate statutory scheme than the Human Rights Act, we have a lot of cases that have both of those allegations, and we do we try to investigate them together, but it's still 2 charges, 2 letters of determination. So that does make things take longer.
What's the oldest complaint that's still in the pipeline?
I don't know the oldest complaint. We were looking at it and we thought 2017.
Oh.
We just resolved our oldest case, a 2015 hearing examiner case that has gone through multiple directors. We issued that earlier this year. That was the oldest case on the hearing unit docket.
That should bump up your average a little.
I hope so.
Yeah. Okay. Any more that we can be doing at the committee to help with the backlog?
No, I mean, we appreciate the committee's advocacy for us and your support, providing additional positions. So very much appreciate that. We also appreciate, we know you receive many constituent inquiries and questions about our delay process, delays and our processing. And so we do appreciate when those issues are raised, because sometimes, it's helpful to have another check on all of our systems, like, is something missing? Where are we? Is someone on leave? So we do appreciate that partnership.
OHR conducted a pilot program to accept attorney drafted charges between July 2024 and March 2025. Can you tell us more about how that's going?
Sure. So the pilot, I believe it concluded in March 2025, or maybe later in the spring of last year. We got very positive feedback. The folks who went through the process had a couple suggestions for how to make it better and more efficient. And so it will be out this quarter, maybe even in the next couple weeks, a final program where we've tweaked some of the things that people raised. I think it'll be very helpful with especially attorneys that appear before us regularly. They know how to draft a charge. We can certainly move those cases without having to go through an extensive intake process. There are attorneys who don't practice before our agency very often, and there may need to be some back and forth with our intake officers for them to understand, here's what we cover and here's what we don't. But I think it will make a significant difference for folks who are represented.
How many cases were closed by conciliation agreements in FY25 and FY26 to date?
So it was 2 last year? Three. So it was 3 in FY25 and I believe 16 in FY26 to date.
Great. You testified the agency has been providing guidance to agencies adopting AI-powered language tools. Could you say more about that?
Sure. So we've had a lot of reach outs to our language access program about agencies wanting to use different types of tools that either have an AI component or machine learning component to see if they could provide quicker translations faster, rather than, if you're sending something out for translation, it can be days or weeks depending on your agency and the need. And so what we wanted to do was make sure that agencies who were doing that were doing so responsibly and figuring out what is appropriate for using AI tools and where it's not. And so our language access program, together with our Office of General Counsel, put out some guidance in November 2025 that really went through best practices for how to use those tools if agencies are seeking to adopt them or are evaluating tools for adoption.
Okay. Okay. The agency response to our question 42B shows a high number of alleged unlawful discrimination in employment, housing, and public accommodations. Can you briefly talk about the trends you're seeing in those areas?
Sure. So, it's difficult with our case management system to really track in real time what the trends are. But some of the things we noticed when we were comparing FY25 numbers and 26 with 24, we were really struck by the number of the increase in charges filed based on homeless status. We had 30 in FY24 and we had over 60, so double in the last year. Which I think is probably a combination of really dire situations for unhoused residents in the district, but also the work that we did to do outreach. So we put together a poster about homelessness as a protected trait. We worked with advocates on what the language should look like, what the design should look like, and then we partnered with DHS to put those up in every shelter in the city. So I think that and we did that during sort of the federal surge. So I think that confluence of events is one trend that really stuck out to me.
Are there any ongoing barriers generally that can be addressed by the committee or the council as a whole?
I think the barriers are similar to the barriers we've discussed previously, but it's, staffing, unfreezing those positions so we're able to have a fully staffed functional agency. It's having additional non-personnel services funding. Because really, when we have a situation where we have a critical need, someone leaves or someone is on leave, or there's just a surge in intake or a surge in investigation or mediation, we can't flexibly pivot to address the surge without pulling people off other jobs. And so that's what we've been doing. You know, managers jump over and try to help. We've repurposed attorneys to do some of these functions. So you know, having additional non-personnel funding to be able to meet those needs on a flexible basis would be very helpful. And then I think, you know, additional operational supports. Being in this role, I've really realized how many hats every single person is wearing. So every director, and I've done the same, is going to focus on funding frontline staff. I am always going to put frontline staff over operationals. However, that means that the folks that do operations and try to keep our phones working, try to deal with tech support, try to staff, you know, deal with all the paper we need and fix the restrooms, like all of that stuff falls on a few people who are just running flat out and exhausted. So I think looking at that to see if could there be some operational support so that as the agency grows, I don't lose really talented people who are just overwhelmed.
Thank you. Thank you all for your testimony today.
Thank you. We really appreciate it.
Absolutely. We are now going to be joined by the Director of the Office of Contracts and Procurement, Nancy Hateman. Really have to be done by 2:30? You said it was at 3. It starts at 3. Well, we'll do our best. Wiggle room. Okay. All right, Ms. Hateman, Director Hateman, would you please raise your right hand? Do you swear or affirm under a penalty of perjury the testimony you're about to give to the Committee on Public Works is the truth, the whole truth, and nothing but the truth? You may begin your testimony.
Good afternoon, Chairperson Nadeau and members of the Committee on Public Works and Operations. I am Nancy Hateman, Chief Procurement Officer of the District of Columbia. I appreciate the opportunity to provide an update to you on the Office of Contracting and Procurement's OCP's performance for fiscal years 25 and 26 to date. At the outset, I want to acknowledge and thank Mayor Muriel Bowser for her leadership over the past 11 years and her growth agenda.
I'm sorry, Director, hold on one second. Friends, it's really loud in here. Can we just ask everyone who's finished to, yeah, we've got ongoing testimony. Go ahead.
Okay. Okay. I want to thank and acknowledge Mayor Bowser for her leadership over the past 11 years and her growth agenda, grounded in building pathways to the middle class, promoting inclusive growth across all 8 wards, and balancing strategic investment to accelerate the district's growth. OCP remains firmly committed to advancing her vision to modernize government operations and procurement in ways that expand opportunity and ensure equitable access for vendors and residents. That vision, which is anchored in a relentless commitment to a fair shot for every DC resident, is closely aligned with OCP's mission. The mission of OCP is to partner with vendors and district agencies to purchase quality goods and services promptly and cost-effectively, ensuring that every procurement action is conducted with fairness and impartiality. We are proud to serve as a trusted partner for the 79 offices and agencies we serve, supporting acquisitions across a diverse portfolio of goods, services, and construction. This work underpins the continuity of government and the delivery of essential services for our residents. Procurement infrastructure modernization. In fiscal year 25, OCP intensified efforts to modernize our procurement infrastructure. This work was designed not only to improve performance in fiscal year 25, but to create a foundation for sustained improvement in fiscal year 26 and beyond. The largest of these projects is the Procurement Automated Support System, PASS, modernization project. Following a strategic pause in fiscal year 24 and 25 due to budgetary constraints, OCP began resuming this project to address serious gaps in our infrastructure. As I have testified before, the PASS system is over 20 years old and is no longer supported by the developer. The goal of the PASS modernization project is simple: transform OCP's procurement infrastructure by reducing manual and siloed processes, shortening administrative lead times, eliminating duplicative data entry, and lowering compliance risk while increasing transparency and data quality. In practice, the modernized PASS will unify the full procurement lifecycle: forecasting, requirements development, solicitation, evaluation, award, performance management, and closeout within a single system of record. It will integrate milestone tracking and dashboards to make procurement administrative lead time, PALT, visible and actionable for program staff and leadership, allowing earlier interventions and more predictable delivery. Vendors will benefit from self-service registration, standardized forms, real-time status updates, and guided checklists that streamline processes and administrative costs, with particular value for small, local, and certified business enterprise firms seeking clearer access to upcoming opportunities. Contracting teams will gain configurable workflows, digital document management, version control, and robust audit trails that strengthen compliance and simplify collaboration across procurement clusters. Outside of the PASS modernization project, OCP has made strides in other areas to improve infrastructure and performance. In fiscal year 25, OCP procurated a vendor evaluation system for DC supply schedule contractors, enabling client agencies to provide feedback on goods and services. This new platform provides a means of strengthening accountability and helps procurement teams make more informed sourcing decisions. Additionally, in partnership with the Office of the Chief Technology Officer, OCP developed the PALT tracking system. This system monitors procurement milestones, surfaces bottlenecks, and shares actionable intelligence with leadership and client agencies. All of this results in greater transparency into timelines and improved management of delivery expectations. Fiscal year 25 performance highlights. In fiscal year 25, the Office of Contracting and Procurement managed an acquisition portfolio totaling $5.7 billion, encompassing high-priority procurements across public safety, health, education, infrastructure, and social services. Each of these procurements required timely execution, rigorous compliance, and demonstrable value for taxpayers, and together they reflect the essential role OCP plays in sustaining core services for district residents. Operationally, fiscal year 25 was a strong year of execution and control. OCP processed 33,000 P-card transactions and issued more than 15,000 purchase orders. These figures illustrate both the scale of daily activity and the discipline with which agency procurement teams and OCP staff work in concert to meet program needs, uphold standards, and move procurements efficiently from planning through award. Our work in fiscal year 25 continued to expand inclusive economic opportunity through the Certified Business Enterprise Program. OCP engaged 512 CBEs, representing $1.5 billion in investment in district businesses. Client agency engagement. Fostering strong relationships with client agencies is foundational to effective procurement. In fiscal year 25, we continued regularly meeting with senior leadership from our client agencies and the OCP procurement teams embedded within. These sessions provided critical insight into agency priorities, enabling OCP to identify risks early, better sequence procurements, and respond quickly to emerging challenges. As we entered fiscal year 26, We committed to expanding these engagements with an emphasis on earlier planning and forecasting alignment, aiming to reduce cycle times and ensure that procurement strategies are tightly matched to program objectives. Vendor and community engagement. Robust engagement with our vendor community is essential to fulfilling our mission. In fiscal year 25, we introduced a refreshed forecasting module on the Contracts and Procurement Transparency Portal, providing more accurate and accessible information on upcoming procurement opportunities. We also continued our robust program of vendor education through a series of virtual workshops that collectively attracted 878 attendees. These sessions offer practical guidance on district procurement processes, compliance requirements, and navigation of the DC supply schedule. To further align outreach with vendor capabilities, we reimagined our flagship event, DC Buys, to OCP Buys, transforming it into a series of focused events organized by commodity and sector. This targeted format increases relevance and ensures vendors receive information that matches their services. Post-event surveys received overwhelmingly positive feedback and noted strong attendee experiences that highlighted how the events aided in resolving outstanding vendor questions by enabling direct dialogue between vendors, agency staff, procurement staff, and agency partners such as Department of Small and Local Business Development and the Office of Risk Management. OCP also actively partnered and participated in other events such as DSLBD's District Connect, DC Health Benefit Exchange's Power Up DC, the Department of General Services Small Business Procurement event, and a small business event hosted by the Washington Metropolitan Area Transit Authority. Surplus property and emergency response. From fiscal year 25 through fiscal year 26 to date, OCP delivered value through two complementary lines of work, managing the district's surplus assets and supporting emergency response activations. The surplus property program continues to deliver substantial value for the district. In fiscal year 25, the program generated a record-breaking $8.2 million in revenue from the sale of 5,920 lots of surplus property, scrap metal, and other disposal activities. The vast majority of these sales were generated in the transportation sector, notably the $1.5 million sale of the DC circulator buses and $877,760 from the United Medical Center liquidation. OCP's proactive approach to surplus property reuse has enabled DC agencies to source essential supplies and equipment from district and federal inventories, creating cost savings. This program underscores our continued commitment to sustainable utilization of district resources. Beyond our standard procurement operations, OCP has played an active role in supporting district government operations during critical periods. OCP leveraged its resources in the most recent snow and ice removal efforts, which enabled the district to carry out essential functions. Another key activation was OCP support of the 60th presidential inauguration, in which we provided procurement assistance to agencies including Homeland Security and Emergency Management, the Metropolitan Police Department, DC Fire and EMS, and the DC Department of Transportation. Our support extended to activations for the general election, the certification of the election on January 6th, and multi-day activation for inaugural activities. Additionally, OCP has provided critical support for other emergency response activations, such as snow emergencies, boil water advisories, the 2024 North Atlantic Treaty Organization Summit, and the tragic aircraft water rescue and recovery operation on the Potomac. These initiatives underscore our ability to deliver rapid, effective procurement solutions in both routine and emergency situations. In conclusion, our performance in fiscal year 25 and fiscal year 26 to date reflects steady progress in operational excellence, stakeholder engagement, and process transparency. As we continue to refine our processes and broaden our engagement efforts, the Office of Contracting and Procurement remains steadfast in its commitment to delivering fair, transparent, and efficient procurement solutions for all district agencies and the communities we serve. We are grateful for the leadership of Mayor Bowser, City Administrator Donahue, and Assistant City Administrator Rodriguez, who have been instrumental in supporting us through the fiscal year as we serve the district. We also extend our appreciation to you, Chairperson Nadeau, and the members of the Committee on Public Works and Operations for their support and for providing us with this opportunity to testify. Thank you for the opportunity, and I welcome any questions you may have.
Thank you very much for your testimony. I want to start with the pass modernization project. During OCP's budget oversight hearing last year, you indicated that OCP would have recommendations from the IT research consultant by the end of June last year. Now your responses indicate you can't provide us with a copy of the recommendations because the process is still underway. Could you clarify whether the study is complete?
Yeah, the study is complete.
Okay, so why can't you share a copy of the recommendation?
Well, because with the recommendations, we're still going through the process of determining the final outcome of which recommendations and which direction we're going. So we have until we have a contract signed and the vendor completely selected, that we are not releasing the report to the public.
Okay, I mean, it would be useful to see the preliminary recommendations, even if you're not going to adopt them all, which was what our request had been.
Yeah, I just would not reveal it at a public meeting.
Okay. So you indicated that the timeline can't be finalized until the district procures the services of a professional system implementer. What's the role of the implementer and why is that required in order to move forward?
Sure. The implementer is responsible for configuring, customizing, and deploying a new IT system or application so that meets the district requirements. Their key responsibilities include translating functional requirements into technical configurations, setting up the software according to the district's needs, moving data from past to the new system, ensuring the system works as intended before go live, and assisting users with system adoption.
Where are you in the process of procuring this service or person?
We are in active negotiations right now with an implementer.
Okay, so that's a one person?
An implementer is actually a company.
Okay.
And it's going to have teams that cover various aspects of the project.
Has the timeline for completion of the pass modernization project shifted?
The timeline is still being finalized completely. We have not moved away from the go live implementation by the end of fiscal year 27, but within that time period, there are still some adjustments being made. And until the implementer is actually on board and we're following the process that they're using, there will be some adjustments in the timeline in between now and 27. But our end date is the end go live at the end of fiscal year 27.
Do you have an estimate of how much additional funding will be needed to complete the project?
We're working on that now for inclusion in the mayor's proposed budget.
Okay. Are any other existing portals being considered for integration with the new pass system, such as the vendor portal and transparency portal?
Yeah, there are considerations. We would not eliminate those functions. For example, how they get integrated will be developed as we go through the implementation, but those functions of transparency portal will continue. And there are several connections and portals that will continue. The manner in which they are done may change slightly just because we're changing away from the past database and some of the warehouses, but they will continue.
So OCP is legally required to upload not only a copy of the contract to the transparency portal, but also several other documents, including all determinations and findings, contract modifications, amendments, and solicitation documents. Does OCP track how many contracts are missing these legally required documents?
Yeah, we track it in Regularly, we track it with our OPIC, Office of Procurement Integrity and Compliance. They do quarterly reviews of a sample of the contract workspaces to determine the compliance with the requirement to uphold all the document types that you mentioned. Right now, we are also having OPIC do a more exhaustive review of the contract workspaces because as we move towards the new system, we need to make sure that the workspaces are in good order to transfer the data to whatever the new system is.
Do you know how many contracts are missing documents?
I do not have that number.
Yeah. The committee would like to see the copies of OPIC's quarterly reviews.
Sure.
Thank you. Okay, so, and then, you also mentioned in your responses 6 procurement forms that are now fillable online. Which forms are those?
Yes, we did 6. They include a determination and findings for contractor responsibility, a determination and findings for a cooperative purchase agreement, determination and findings for emergency procurement, a preliminary notice of award of the option period, an amendment of the solicitation and modification of the solicitation.
Thank you. Are there other procurement forms that are not currently fillable online?
There are other forms that are not fillable and there are other forms that we could do. Right now, we're trying to assess about what is the best way to use our resources because as we move to the new system, and we'll be starting that soon, there will be templates available in the system. And so it does take time and effort and resources to develop the fillable form. So right now we're weighing which is the best use of our resources for fillable forms. But the idea is that as many templates and forms that we can put in the new system that would be filled through that is our main goal.
Okay. When was the PALT system implemented?
Well, the PALT system was developed to start at earlier in fiscal year 26. We in OCP started using it around November. And we have trained all of our contracting personnel on it now. And our next phase is starting to train agencies on how to use the data in it. The gap between training our personnel and training the agencies is we had to get data in the system in order for the agencies to look at and understand how to use the system.
And so is PALT a functionality in PASS or is it a separate system?
PALT right now is a separate system.
Okay. And is it going to remain separate or integrated into the new system?
If we can, if the new system, and I think the new system will have a lot of the PALT features in that. And so the goal would be to use whatever PALT features are in the new system. And then if we have to supplement it in any way, we can consider that. But ideally, we want the system to be able to generate the information without staff having to enter it.
Oh, so you're training everybody now on PALT, but it's not really going to exist?
It's going to exist for the next year and a half.
Okay. Oy, all right. Can you list which stages of procurement are going to be included in PALT?
Sure. The stages that we have, there's 5 of them. Pre-solicitation, solicitation, pre-award, award, and completed.
Okay. How many client agencies are, I guess, going to be using PALT? No one's using it yet?
Well, we're using it for all the agencies and offices we support, so that would be 79.
Okay, got it. Right. In your responses to our questions, you listed several circumstances under which a company must be invited to participate in a solicitation rather than the solicitation being open for all applicants who would like to be considered. While several of them made sense, such as sole source, emergency contracts, and DSS, a few of them were a little concerning. Can you talk a bit about small business set-asides?
Okay, so small business set-asides are something that exists by law, by the law for the Department of Small and Local Business Development. And so within that, there's various ways of having set-asides. So one is that, well, first of all, the business in order to be eligible, has to be certified as a small business by DSLBD. So that's the first step. And then after that, if the contract is 250,000 or less, we have to look at qualified small businesses first. And then if there are not at least 2 qualified small businesses, then we can look at whether there are qualified CBE certified businesses, which is the more generic category. Within that, we look first at, is the business, is the service or good available on the DC supply schedule? And if not, if it is, we set it aside for only those vendors on that specific certified supply schedule contract. If it's not available on the supply schedule, or if there's not at least 2 qualified vendors who can provide it at reasonable prices, then we just look to the larger certified small business community. They don't have to have a supply schedule at that point. And then if we are unable to procure it through that market, then we go to the open market. Now, those are the set-asides in law. What we also do is for those procurements that are not covered by that set-aside, in other words, they're over 250,000, we do have the ability to choose to set aside specific procurements based on whether there are at least 2 qualified certified small business enterprises and whether we can get a fair and reasonable price. The mandatory ones are for 250,000 and under. Above 250,000, we can choose to set it aside. And also if it's above 250,000, it is a statutory requirement that we do a 35% subcontracting set aside for small businesses.
Okay, thank you. Can you explain the criteria that determines when a GSA master agreement or other cooperative purchase agreement is used?
Okay, well, in our DCMR, DC Municipal Regulations, Chapter 21, we set forth a priority for use of sources. So I will just run through that quickly because GSA and cooperatives are not the first source that we look at. We look at existing agency inventory. So obviously, if we already have it here, then we use it. If there's excess personal property that is available from our surplus property division, then we get into the different types of contracts, requirements contracts. Do we already have a contract in place that says the district will buy all of something from that particular vendor? Then we look at our existing indefinite quantity contracts. And then we look at the the subcontracting set aside, not the subcontracting, the CBE set asides that I just mentioned, 250 or less supply schedules. Then we look at this 250,000 or less for certified businesses. Then after we go through those various sources, then we get to the ones where you can look at open market, GSA or cooperative agreements. And what we're going to use, whether we're going to use a federal schedule or cooperative purchase depends on a number of factors, including let's say, for example, in cooperative purchasing, we look at, is this something that's available from our certified business enterprise community already? And if it is, then we would go to that community first and look to obtaining it there. And so for each cooperative purchase, the contracting officer has to identify in that DNF that I mentioned, whether what the results were of looking at the certified business community before going that route. And then with federal schedules, we again also look at what our certified business enterprise community can do. Now, there are advantages to using both the federal schedules and the cooperative purchasing agreements, which we get the benefit of the economies of scale because they are especially in the cooperative purchasing, it's on behalf of numerous jurisdictions. So you do get the benefit of economies of scale. Also, sometimes the procurement time is lessened because those are already competed contracts versus us having to do a contract from scratch. And so if time is important, that those are factors that we could consider as well.
Thank you. We also received reports of small business owners not being allowed or invited to apply for certain solicitations. Instead, they've had to request invitations. In response, have received mixed messages on whether they could apply. Could you clarify what type of solicitations function in this manner?
Okay, I think I would want to explain the process, which is first, anybody who wants to respond to a solicitation needs to have been registered, needs to be registered and pass.
Okay.
And in order to be invited to respond to a solicitation, which means that you're already registered, you have to be registered and pass.
Okay.
So some vendors, if they're not registered and pass already, they will have to do that in order to be sent the solicitation link to actually respond.
Okay.
So that's the first thing. And then sometimes solicitations are limited to, let's say if it's a small business set aside. If, for example, we know even if the vendor is registered and pass, but we know they're not a small business, they're not going to be invited to respond because they are not eligible for award.
Could you talk about how can cooperative agreements negatively impact small businesses?
I think that cooperative agreements have the benefit, like I said, of the pricing for things. But cooperative agreements are also for things that are commonly used among many jurisdictions. So especially I think for small businesses, if you are based in the district, for example, there are many things that we buy that are not even available on cooperative agreements. And so that line of business would not be affected at all by a cooperative agreement.
Okay. I would like to talk about some possible legislative updates. In your responses, you mentioned one reform of council review procedures could be authorizing the use of annual plans of contracts for goods and services, similar to the annual plan for federal highway contracts. Can you say more about that?
Yeah, I think for the annual federal plan of federal contracts, it's been very beneficial where just the projects are listed at the beginning of the year. And then if that plan is accepted and approved by council, then we can just proceed with awarding. And I think there's advantage to that for other kinds of projects as well. And so one is locally funded highway projects. We think the analogy from federal highway projects to local funded highway projects holds. Another one is for district supply schedule contracts. And we think that that would be beneficial because the supplies schedule contracts are very structured and they're in certain categories. And so really, if we could just have the approval at, let's say, at the beginning of the year of ones we're going to proceed with, that would be beneficial. I think one that really has come up in discussions that we've had more lately is vehicle purchases that are funded with capital funds. I think that you probably may have heard that there is a long lead time for ordering equipment such as fire apparatus. And so if we can just have our capital plan and get those purchases approved, let's say they want to purchase 20 ambulances or whatever, that they get there is the approval to purchase 20 ambulances, and then we don't have to come back to the council. We can just reduce the procurement time in that manner. That would be beneficial. So those are, I think, the three most relevant examples that I have.
And how would exempting option exercises from full review improve the current procurement process?
Well, I think with the options right now, there's council reviews options in two ways. One is if the council has not reviewed the option at all previously, or if it's there's been a material change, it goes through the complete review with the long form council summary and all the documents that go with that. If there are no material changes right now, the option is submitted in the short form or streamlined version. So there is already the streamlined version, but in most cases, if there's no change to the contract, the really the pricing to for the option year is already set forth in the contract. The council has already seen the contract, so it would reduce the administrative efforts for both us and for the council to be reviewing numerous options. And I think that I don't have the exact number, but I think the number of options might be somewhere around 150 or so per year. So I think that that would really help that would allow the council and us to focus on those things that are new awards or things that have issues versus things that are very routine standard process actions.
Mhm. Can you talk about any updates to the supply schedule your office may be exploring?
Well, we're looking at the supply schedule from a few different angles right now. One is the statute currently authorizes collection of a 1% fee. I guess it's called a rebate in the statute, but we're looking at the collection of that because that's terribly inefficient to collect it right now. So we're looking at ways that we can improve the collection. We're also looking at, we have schedules in 16 categories. Not all the categories are used to the same extent. So we're really we're going to look at, are some of those categories still needed? And then I think the biggest thing is the automation, looking at how we can get more of the information online. So how we can have more availability of the documents so that they don't have to submit paper spreadsheets of their pricing. And then the ordering aspect of that is ultimately, I would love to have and I think the new system will allow us to do this, is have the contracts, once they're in place and the pricing is in the system, that a requisitioner from an agency could directly place the order for what they need and pay for it through their agency's purchase card or budget, however the mechanism is. So those are the 4 areas that I would focus on.
And do those need to be done through legislation?
None of those need to be done through legislation.
What is OCP's assessment of the pay for performance contracts? Do you see any potential benefits or disadvantages?
Well, I think there are benefits, and there are some that are done in certain areas that we do already, but I think the issue with those is always looking at what you are incentivizing in the contract. And so for benefits, obviously it encourages results-driven performance. There is that accountability and transparency aspect, and it supports program improvement. However, challenges are risk of misaligned assessments if the metrics are poorly designed, or if you can't measure it either. You have to be able to measure it. It does require more involvement in terms of data tracking and data collection and data tracking. And I think that it's suitable for those services that can be quantified. If it's hard to quantify something, a pay for performance is not going to be beneficial.
Yeah. Okay. Sorry. Were you gonna
Oh, I was just going to add, I think we've seen it in some of the contracts we've seen are some training programs and occupational job development kind of things, where you can set up, in the ones I'm thinking of, you can set up intervals and you look at what needs to be achieved by that interval, and then if you can pay for it. But I think one of the hardest things is for most people, the data collection and the data tracking and making sure you're incentivizing the right things.
Don't we have a pay for performance streetlight contract right now?
I would say that that was a public-private partnership,
Okay.
and I'm not familiar with the details of it, but
Okay.
so.
Interesting. So that was done outside of OCP?
It was done through the public-private partnership office, which may have become part of DIMPED at some point.
Yeah. No, I remember.
Yeah.
That's a pretty huge contract to have been done outside our entire procurement process. So I didn't realize that piece of it.
Yeah, well, we had some people that individually supported it, but it was supporting it through the process that was set forth in the law that describes what steps you have to follow for
For a
P3 projects.
Okay. Got it. Got it. I want to talk a bit about the ACFR findings presented at last week's hearing. So finding 2025-1 referenced an instance with DemPed in which they procured services under sole source, but the required determinations and findings document did not include the market survey or statement explaining why a market survey was not needed. Can you clarify whether a market survey was completed or not?
I do not know that procurement was not done through OCP.
Okay, so DemPed is able to do their own procurement?
Correct. Mhm.
Okay. And similarly, finding 2025-3 cited an instance with DHS in which a software contract was incorrectly classified as sole source in the procurement system and was procured without evidence of a certificate of clean hands.
Mhm.
What risks are associated with not obtaining products or services using the proper procurement methods?
Well, I think one of the main risks and something we run into on occasion is the data. The data becomes less reliable because if you're looking at the data, whether it's for audit purposes or any purpose, when you manually enter data, you have more opportunity for error. And that's part of what we're hoping in the system, when more of the processes are conducted in the system as opposed to outside of it and then just uploaded, that reduces the errors in the data and increases the reliability of the data.
Okay, given that both findings cite missing required documents, does OCP plan to refresh procurement policies and procedures to ensure controls are strengthened? I mean, is there anything you're doing with PASS that's going to help in these scenarios?
Yes, with the new past modernization, we will have many of these documents in the system, and there will be certain steps that if you choose, you're doing certain steps, the system will then have some pop-ups or triggers that ensure that you have other things that you know you have to do. So the system will do more guiding than currently is available under PASS.
All right, and finding 25-2 found that the DMV, working with OCP, procured traffic violation ticket processing services in the amount of $5.2 million using emergency procurements and used consecutive emergency contracts to cover sustained operational needs instead of initiating a timely competitive procurement. Is it common to use emergency procedures for routine ongoing services?
Well, I think my answer to this is going to just go back a little bit. The circumstance of this was probably not the usual circumstance. OCP had issued a competitive RFP, request for proposals. In that case, we had gotten one response back, but the response did not meet the requirements of the solicitation. And with only one, so we were trying to do a competitive procurement. And then the fact that response was for a legacy contract. I mean, it's a legacy system. I don't know how many years the district has had this system, but it's many, many years that we've had it, and it's a complex system. So at that point, when we couldn't award under that contract, we ended up having discussions with the Department of Motor Vehicles, and we all agreed that rather than doing that solicitation for just 1 year, we would do a 5-year contract. So we canceled the RFP and we then entered into negotiations on a sole source basis to do a 5-year contract for the legacy system. During that time, the incumbent sold that line of business to a company that had never done business with the district, and they were a foreign entity. So then we had additional negotiation delays because of the fact we were dealing with a new business that had not previously done business with the district. So that, to me alone, is an unusual situation. And then second, when you have something with a legacy system like that, we couldn't have done an emergency competition. The time to implement a new system would have been 12 or more months. So timeline became problematic as well. And when we had only gotten one response to the prior solicitation, we really only had that one vendor to go to on an emergency basis. So I would say that emergency contracts can be used. The law does allow them to be used when we need to continue to prevent disruption to government functions. And so that was what was the case in this situation, because it was the system for processing all the payments of all the tickets. So I understand your question, but I also think this was not a normal solicitation. And sometimes emergency contracts have to be used as a bridge contract, because you can't do emergency contract at the most is going to be 120 days, usually 90 days. You're not necessarily going to get people other than the incumbent who's already there to provide that service with the guarantee of only a 90 or 120-day contract.
So is the next iteration of this contract going to be an emergency contract?
That we have a 5-year contract in place, and
Okay.
during this time, there is going to be further review by Department of Motor Vehicles on systems that are available and what the best method is for processing tickets.
Does OCP agree that this finding is a control deficiency?
No, we don't agree that it's a control deficiency, because these were just used to maintain critical functions while the contract moves through the process. So it was we don't view it as a control deficiency.
Okay. All right, I'm going to ask some questions about things we heard from public witnesses today.
Okay.
As OCP prepares the upcoming food services solicitation for the Department of Corrections, what specific performance deficiencies from the current contract have you identified?
I would have to talk to the contracting officer about what deficiencies have been identified.
Okay. Would the new solicitation include nutritional standards?
It will have standards in it, and those standards we obtain from the Department of Corrections.
Okay, so they would they align with the Security C statutory requirements? I mean, that would make sense.
Department of Corrections would have to identify what they need to align with.
Oh, okay. So you guys don't also look through the new statutes that apply? Or
Well, we depend on what I call the program agency
okay.
to be aware of any statutory requirements that would pertain to the food that they need to obtain.
Okay. And how frequently does OCP evaluate vendor performance under the current contract?
It's done at least on an annual basis.
Okay. Have you issued any notices of concern, default, or corrective action to the current vendor?
I would have to check, but I am not aware of any, but I would have to check.
Okay. What steps will you take to expand the vendor pool for the solicitation?
Well, what we do, we post it on our website, which would be available to anyone interested in it. If and corrections identifies additional vendors that we need to send it to, we can send it. But our main method of publicizing solicitations is on our website, although this one would be over $250,000, so it would also be in a newspaper of general circulation. But the main way people find out about procurements is through our website.
So my understanding is that one of the criteria of this contract is prior correctional food service experience. And well, I guess it's required or weighted. And that there's a very limited pool of vendors who have prior correctional food service experience. In your opinion, is it necessary to have that requirement?
I think that, well, again, I would defer to DOC on it also, but I do believe that providing food service in an institutional environment that has the security requirements of a correctional institution is very different than providing it in other contexts, in terms of maintaining the safety of the silverware, the things that can be used to serve, the security, there is a lot that goes with it that is way beyond just sort of a normal food service
Mhm.
contract.
Isn't that something that could be, I mean, if there are complaints about the current vendor and there's really only one vendor with the prior
There are multiple vendors that have prior food service contract experience.
in correctional institutions?
Yes.
That have been bidding on our contracts?
Yes, we have had this, we have had other vendors besides the current vendor.
Okay, but they are specifically vendors that have.
That have that in experience, yes.
Okay. But when it comes to improving services, don't we seek to also deepen the bench, and is there work that we do pre-solicitation to give people the information they need to understand how to run a contract like this?
Well, I think it's a difference between us advertising something in a sufficient manner that those who are able to perform can do it. But there's also the question of how much time do we give vendors to develop that expertise as well?
Okay. What are the benefits of using a community advisory board? And is this a common practice for contracts like this?
It's not a common practice for contracts.
Are there any benefits to it?
Well, I think the benefits would be more to the program agency than to procurement itself. Because I think that would give the program agency the feedback they need on the program.
And do you know anything about whether the requirements for the contract are going to address outdoor recreation space, natural light, and programming areas?
For food?
Mm-hmm. That seems to be a
I don't-
concern that was raised today.
Okay, but I'm not sure how I connect outdoor space and light to the food contract, because the food contract is specifically to serve food.
You want me to ask about that contract too? Okay, we're going to follow up with some questions about the construction contract, which I
Okay.
think that was related to,
Okay,
which
yeah.
makes a little more sense.
Yeah, that
Okay.
makes sense in that context. Yeah.
Okay. Yep, that was a big jump in my questions that did not have transition, so that's why we know, now we know. Okay. Okay, and yes, is the contract for the new jail coming to you, or is that going
No.
to be Dem?
That is
Pet?
not, OCP is not doing that contract.
Okay, all right, okay. I think we're gonna leave it there for today.
Okay.
We may have some follow-ups in writing. But I thank you very much for your testimony
Okay.
today.
Well, thank you.
And this concludes today's performance oversight hearing. If you plan on submitting written testimony for the record, please do so by going to the council hearing management system and submit your testimony by Wednesday, March 4th at 5:30 p.m. The time is 2:22 p.m. and this hearing is adjourned.